ನೈಸ್ಲೆಟ್ ಒಂದೇ ಒಂದಿದ್ದ
ಎರಡು ಅದು ಮಳಿನಿ
ಮಾರಿ
ಮಾರಿ
ಬೇರೆ ಯಾವುದು ಬಂದಿಲ್ಲ ಅಲ್ಲ, ಬೆಳಗ್ಗೆ ಚೆಕ್ ಮಾಡಿದ್ರ? ಬಂದಿಲ್ಲ.
ಟ್ರಾಫಿಕ್ ತುಂಬಾ ಜಾಸ್ತಿ ಇದೆ.
ಕೊಡಿ. ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಏನು? What is
They also grant people for the capital loan and then get the NOC from the AAD. When it's not for NOC, but it's cancelled by
please
this one, cancelled at please. As well as take one question, hand over question tomorrow.
you have established your industry already.
Small scale industries and oxygen gas manufacturing.
Mr. Chandrasekhar, our copy serve ಮಾಡಿ end of the list. GMK allotment cancel, land acquisition ಬರಲ್ಲ, correct? ಅವ್ರು ಹೇಳೋದು correct. GMK IDB ಬರ, LAK IDB, GMK IDB. So ಬೇಗ ಓಡಿ, ಇಲ್ಲಿಗೆ ಬರಲ್ಲ, ಕರೆಕ್ಟ್.
Serial number 34, Your Lordship.
Just a moment. 30.
Serial number 32, Your Lord.
30.1. Have you informed everybody? Petitioner in 30 no inform ಮಾಡಿದಿರಾ? 30 petitioner inform ಮಾಡಿದಿರಾ? ಮಾಡ್ತೀವಿ ಬೇಡ. Learned counsel, ಇವಾಗ ಯಾರು ಇದ್ದಾರೆ ಇದರಲ್ಲಿ? ಯಾವ್ದ್ರಲ್ಲಿ?
33, I am appearing for correspondent.
Shri B.V. Ramurthy has entered appearance, registry that delete the name of Shri Shanmugappa. 33.1 ಅಲ್ಲಿ? You informed him. ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಕೇಸ್ ತಮ್ಮಯ್ಯನ ಕಲ್ಯಾಣ?
I am for the respondent. Inar Girish.
ನಿಮ್ಮ 33.3 ಅಲ್ಲಿ? You will file wakalat. Shri B.V. Ramurthy undertakes to file wakalat for respondent for petitioner in 33.3. Place is that print his name, delete name of Shanmugappa. 33.4 ಅಲ್ಲಿ Ramurthy has entered appearance, delete Shanmugappa. 33.1 ಅಲ್ಲಿ Shri Kalyan has entered appearance, delete the name of Shri K.S. Timaya.
35, Your Lord.
Shri Ramurthy seeks for objections ಹಾಕಿದ್ದೀರಾ Mr. Girisha?
Objections filed, my lord.
Filed.
Objection filed.
ಇದೇನಿದೆ IA 2 of 17 for additional documents for final disposal. Non-amendment ಏನೋ ಇದೆ. ಆ ಫೈಲ್ ಕೊಡಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಲಿ, ಇಲ್ಲ ಇವಾಗಲೇ ಮಾಡಿ. ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತ ಬಂದಿದೆ ಅಲ್ಲ, ಇಲ್ಲೇ ಮಾಡಿ 11 counsel for the petitioner seeks for and is granted 2 weeks time. Released on 25/7, 22/7.
Serial number 35, your lordship.
1/8. Yes, serial number?
35. I have returned the file, your lordship. I have to file the memo for retirement.
35, Learned counsel for the petitioner seeks for and is granted 2 weeks time, released on 19/7.
Please, your
Lordship 34, serial number 34.
33 ಅಲ್ಲಿ 1/8 ಅಲ್ಲ 2/8 interim order earlier granted is extended.
Lordship, serial number 34.
Yes.
I seek for 1 week's time, Your Lordship. I have informed the other side.
What is this IA 1 of 2022 for impleading, madam?
Impleading in that.
We will allow it. You will file objection. 34.1. Learned counsel for the petitioner seeks for and is granted 2 weeks time to file objections to IA 1 of 2022. Released on 25/7. Interim order earlier granted is extended to next year. Cell number 25. Yes, ಏನಕ್ಕೆ 2 weeks time? 25. Learned counsel for the respondent seeks for and is granted 2 weeks time to file the statement of objection. IA 1 of 2022 is allowed. Objections, if any, to be filed on or before 22nd, released on 26th. Or earlier. You are for the petitioner. Have you informed the respondent? 43. Learned counsel for the petitioner seeks for and is granted 2 weeks time to file his rejoinder to the statement of objections filed by the respondents. Rejoinder, if any, to be filed on or before 21st, released on 26th. ಏನಕ್ಕೆ ಟೈಮ್ ನಿಮಗೆ ಏನು ರೀಸನ್ ಹೇಳಿದ್ರೆ ನೀವು ಬರೀ ಅಜ್ಜನ ಅಂತ 40. Learned counsel for the petitioner seeks for and is granted 1 week's time to get ready and address arguments. Released on 12/7.
My lord, serial number 54, my lord, appearing for the
Yes.
kindly grant us 2 weeks time to file a statement of objection, my lord. We have
Have you informed the petitioner?
Yes, my lord, we have informed the petitioner.
54. Learned counsel for the respondent seeks for and is granted 2 weeks time. Finally, to file a statement of objection. Objections, if any, to be filed on or before 21st, released on 26th.
Serial number 49, my
Yes.
3 days time, what I see. Friday, my
Have
I'll
you
make
informed
this,
Mr. Lakshmishra?
because I need to bring the LS on record, my lord. The petitioner is no more. Friday, my lord.
Learned counsel for the petitioner submit that the petitioner is expired. He seeks for and is granted a week's time. 3 ದಿನದಲ್ಲಿ ಆಗ್ತೀರಾ?
ಆಗ್ತೀನಿ, ready ಇದೆ sir.
Seeks for and is granted 2 weeks time to file necessary application. Released on 12/7.
Much obligation.
Is your client going to come and address arguments, Mr. Counsel? 2019 matter, that's not a submission to be made. There is evidence we understand. There is to be argued by you. Now that you make a mention of. Have you informed the petitioner? You are careful. Counsel for respondent number 3 seeks for and is granted 2 weeks time finally to file a statement of objections. Statement of objections, if any, to be filed on or before 21/7, pre-list on 26/7. We are in page number where AB. Please don't interrupt me.
Page number 12, serial number 56 to 69. Page number 13, serial number 70 to 83. Page number 14, serial number 84 to 92.
Serial number 89, my lord. I pray for 1 week
Yes.
time, my lord. I am for your respondent, BDA. I pray for 1 week time to file objection, my lord. 89.
Have you informed the petitioner, Mr. Girisha?
Yes, my lord. Yes, my lord.
89. Learned counsel for respondent number 2 seeks for and is granted 2 weeks time finally to file a statement of objection if any by 21st, pre-list on 26th.
Page number 50, serial number 93 to 87.
My lord, serial number 93, my lord.
Yes.
For appearing for R2, my lord, kindly grant us 10 days time, my lord.
Have you informed the petitioner, madam, and the other counsels?
Yes, my lord, we have informed.
I am
All
for
the
the
counsels you are
respondent.
informed.
I am for the respondent. I am informed.
Yes, Mr. Sebastian. Any objection?
No objection.
That 93, Learned counsel for respondent number 2 seeks for and is granted 2 weeks time finally to file a statement of objection by 21st, pre-list on 26th.
Page number 16, serial number 98 to 104. Page number 17, serial number 105 to 109. Page number 18, serial number 110.
ಅದು ಬಂದಾಗೆ in 110. We cannot now pass the order. We'll take it up when it's taken up our game.
Serial number 1, Rajeshwara PM.
Mr. Rajeshwara. Serial number? Serial number? Who is appearing in this matter, Mr. Krishna? You are appearing or Mr. Lakshmi Shrav? 30. Lakshmi Shrava. Shri G. Lakshmi Shrava has entered appearance and registers direct delete the name of Shri K. Krishna. Objections ಹಾಕಿದ್ದಾರಾ? ನಿಮ್ಮ ಫೈಲ್ ನಿಮ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂತೀರ? Learned counsel for the petitioner seeks for and is granted 2 weeks time. Finally, relist on 26/7. Objections if any on behalf of the respondent to be filed within the said period. Yes, madam. ನಿಮಗೆ ಸರ್ವ್ ಮಾಡಿದಾರಾ? Learned AG accepts notice for respondent number 1, Shri P. Chandrasekhar accepts notice for respondent number 2 and 3. Counsel for petitioner to serve a copy of the petition along with annexures on the said counsels. Objections if any by 21st, relist on 25th. Q&R ಏನು? Alternative site. AGA accepts notice for respondent number 1. ಯಾರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅದರಲ್ಲಿ? Shri Manjunath S. Vairareti is directed to accept notice for respondent number 2, issue notice to respondent number 3. Returnable by ಯಾವತ್ತು ಹೋಗಿದೆ ಅದು? Connected matter number ಏನು ಅವತ್ತೇ ಬರ್ತಾರಲ್ಲ ಎಲ್ಲರಿಗೂ connect the above matter with WP 7720 of 2022 ಅಷ್ಟೇ ಡೇಟ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅದು ಎಂಟ್ರಿ ಮಾಡರ್ ಏನಾದ್ರು ಇದೆಯಾ pass over 3 and 4 peripheral ring road we have posted on 12th ಏನೋ ಇದೆ ಅವತ್ತೇ ತಗೊಳ್ಳೋಣ ಇಲ್ಲ ವಾಷಿಂಗು ಲ್ಯಾಪ್ಸಿಂಗ್ ಎಲ್ಲ ಒಂದೇ ಹಳಿಯ ಎಲ್ಲ ಮಗಳ ಗಂಡ ಅಂದಂಗೆ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಎಫೆಕ್ಟ್ ಫುಲ್ ಕನ್ಸಿಡರ್ ಮಾಡಲೇಬೇಕಲ್ಲ we'll order notice so they'll get prepared and we'll have it on 12th ಇದೆಯಲ್ಲ ಯಾವುದು 12/7 take it up on 12/7 AG is directed to accept notice for respond number 1 ಅದರಲ್ಲಿ ನೀವಿದ್ದೀರಲ್ಲ ಮಿಸ್ಟರ್ ಕೃಷ್ಣ ಎಲ್ಲದರಲ್ಲೂ Shri K. Krishna is directed to accept notice for respond number 2 counsel for the petitioner to serve copies of the petition along with annexures on the said counsels. Connect the above matter with WP 6/3/2022. We'll consider it on that date. Based on 12/7. 4 same. Yes. And AG accepts notice for respond number 1. The Poonam Patil is directed to accept notice for respond number 2 and 3. Counsel for the petitioner to serve copies of the objections if any by 21, released on 26th. Six, sir. Copy not served. Five. Notice ಆಯ್ತು ಪೂನಂ ಪಾಠ ನಿಮ್ದು 6 ನೀವ್ಯಾವುದು ವಿ ಶುಡ್ ನೋಟಿಸ್ ನೀವು ಆದ್ಮೇಲೆ ಬರ್ತಾ ಇದ್ದೀರಿ ಆಯ್ತು serial number 6 ಈ ಕಡೆ ಬನ್ನಿ yes then settle ಆಗಿದೆಯಾ matters no litigation now no, you are ready but is there any dispute pending No, as long as the suit is there, there cannot be 29. Disposal. That's the problem with this. In fact, we have you reject ಮಾಡ್ಸ್ಕೊಂಡು ಬನ್ನಿ. We'll reserve you that liberty. If there is a suit pending 7/11 ಆಮೇಲೆ GMCPC ಎಲ್ಲ ಬರುತ್ತೆ ಅದುವರೆಗೂ ಸುಮ್ಮನೆ ಪೆಂಡಿಂಗ್ ಬೇಡ if there is no suit we'll allow this if there is a suit we can't ಅದೇ ನೋಡಿ ಕೇಳಿದ್ವಿ the petitioner is before this court seeking for learned AG accept notice for respond number 1 Shri Gopal accept notice for respond number 2 and 3. Petitioner is before this court seeking for the following reliefs. Shri Hari fairly submits, learned counsel for the petitioner fairly submits that there is a litigation pending as regards the property. There is a second round of litigation which is pending as regards the property. Reserving liberty to the petitioner to approach this court once again after the resolution of disputes in the said suit, the petition is disposed of. are appearing, Mr. Sachin? Hmm.
Last time I had to pay the
You have filed your objection. Shri B.S. Sachin has entered appearance for respond number 2 and 3. Registry is directed to print his name as such and delete the name of Shri Keshav R. Agnihotri as that appearing for respond number 2 and 3. Shri B.S. Sachin submits that the objections have been filed yesterday. When were you supposed to file, Mr. Sachin? And what was yesterday's date? Yakappa in Martira. We have directed the commissioner to be present if not filed on 30th. Noticing that the matter is of the year 2015, 7 years in the pending either for BDS objection. Records are in your office. From where do you secure? You cannot create documents. What is there, you have to file. You are a statutory authority, you have to only place what is the truth. Ashta, you have no personal interest. Adik 7 varsha beka. Not work like that. Please stick to your timelines. 7 years. ಏನಕ್ಕೆ ಕಾಯ್ಬೇಕು ನಿಮ್ಮ ಇದರಿಂದ? ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನೀವೇನೋ ಒಂದು ಮಾಡಿದ್ರಿ ಅದಕ್ಕೆ ಬಂದ್ರು. ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ ಕ್ಲೈಂಟ್ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾವು. This is not to the advocate, this is to your BDA. Submit that he has filed this statement of objections yesterday. The rule of the order sheet indicates that the statement of objection had to be filed by 30/6/2022. However, taking note of the fact that finally objections have been filed, the delay in filing the same is condoned. What about the
DD? They are given wrong DD because the order to be advocate. They are given to counsel.
to the learned counsel for the petition? The cost to be remitted to learned counselor. It should go to the council or to library fund. Na ಜಾಸ್ತಿ ಅಂದ್ರೆ ಕೇಸಲ್ಲೇ ಸರ್. And counsel for the respondent submit that the cost to be remitted by next date. Relist on 12/7.
I appear for the respondent. My lord, this honorable court, while disposing of the writ petition, directed the trial court to dispose of the matter within a period of 60 days. My lord, I think the learned trial judge written a letter seeking extension of time.
Who is for the decree holder?
I appear for the decree holder, my lord, who is the respondent before my lords.
So you are the one delaying the matter and Kelkar.
Not the one delaying the matter, my lord. Why should I? I need the money.
You filed applications after application and documents.
Calling upon him to my lord, the
ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ ಇಲ್ಲ ನಾವು ಡೇಟ್ ಅನ್ನು ಫಿಕ್ಸ್
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ಹೇಳಿದ್ರಿ calling upon me to produce the proof of his income. The 12th condition, my lord, the councils are free to produce the printout with the uploaded copy this order. And before that, my lord, calling upon me to produce is the document, whatever the properties you have. I filed an application calling upon him.
Simple inquiry, you take 45 days to produce the document.
No, they are supposed to produce, my lord, because I filed an application calling upon them to produce. They are delaying it, my lord.
The second additional senior civil judge and CJM, Mangur DK, as wide letter dated 16/3/2022, sought for extension of time to dispose of execution case number 11 of 2016. Taking into consideration the reasons stated in the said letter and accepting the submission of the counsel for the respondent that they will not delay the matter any further, the time granted earlier is extended by another 3 months from the date of receipt of a copy of the order by the execution court.
Obliged.
Serial number 9.
Shri Basaraj ST has entered appearance for respondent number 1. Registry direct delete the name of MN Sudev Egde, Ravikaran G. Kiran CV and Ravikaran G as that appearing for respondent number 1. File ಮಾಡಿದಿರಾ? ಯಾವಾಗ ಮಾಡಿದ್ರಿ? Counsel for the respondent number 1 submit that he has filed the statement of objections on 1/7. None appears for the petitioner. Relist on considering that the objections have been finally filed, accepting the request of the counsel for respondent, costs imposed are waived. Relist on Mr. Pujari. Relist on 19/7. Sir ಮಾಡಿದಿರಾ ಅವ್ರಿಗೆ?
Serial number 10.
Counsel for the petitioner has filed a memo dated 24/1/2022 signed by the petitioner and the counsel for the petitioner, stating that the representation which the petitioner had sought for consideration has been disposed of. In view of the above, the petitioner seeks for withdrawal of the above petition. Accepting the memo and the counsel and the submission of the letter and counsel for the petitioner, the petition is dismissed as withdrawn. Shri B. Vachan has entered appearance for respondent number 1. Memo of retirement filed by Shri C. Ramakrishna is accepted. He is discharged from the matter.
Appear for the petitioner.
Shri B. S. Sachin has entered appearance for the respondent 1 and 2. Hence, memo of retirement filed by C. Ramakrishna is accepted and he is discharged from the matter. ಯಾವಾಗ? See, this NOC business. Why one council ಬಂದಾಗ or instruction ಕೊಟ್ಟು ಮುಗಿಸ್ಬೇಕು? So again, this is a little better 3 years. But now that you have appeared, you will be facing the ಯಾರು ಸಿಗ್ತಾರ ಅವರು? Shri B. S. Sachin seeks for and is granted. ಎಷ್ಟು? 2 weeks time. Finally, to file a statement of objection. Objections if any to be filed on or before 21st, released on 26th.
Interim order may be extended.
Interim order earlier granted is extended till next day.
Obliged.
In time, delay in the application. Counsel for the petition submitted the applications are ready and you will be filing the same during the course of the day. Released on 12/7. Objections active, Mr. ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ? Wherein counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application. And counsel for respondent also seeks for 2 weeks time to file a statement of objection. Objection is finished by 21st, released on 26th. In persons of the order dated 14/6/2022, the registrar judicial has filed his report. In the report, it is stated that the concerned caseworker is handling nearly 7,500 cases, and due to numerous matters in which notice had to be issued, there was a delay in issuing notice in the present matter. The report is accepted. However, the registrar judicial is directed to appoint suitable number of persons in the concerned branch so that there is no delay in issuance of summons. Then I could notice insufficient addressing. You have to find the address alone. Last known address is yesterday open. You have to find out the address. Last known. See, any order passed will not anyhow to your benefit. They'll say that I have not been served. It's in your interest that you trace out the address. You have to trace it out. Your paper publication or ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತು. Please give proper address. The notice issued to respondent number 3 has been returned as insufficient address. It is for the petitioner to obtain the proper address for service. 2 weeks time is granted for doing the needful. Released on 26/7. ಯಾರು ಹಾಕಿದ್ರು ನಂಬರು ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಪವನ್ ಶ್ಯಾಮ್. This is as regards the FIR and crime number. The memo of withdrawal dated 4/6/2021 has been wrongly put up in the present matter. Hence, the said memo is rejected. Yes. Objections. New secretary Nimunna Kada. Counsel for the respondent seeks for and is granted 2 weeks time finally to file a statement of objection. Objections if any by 21st, released on 26th. Interim order earlier granted is extended to next day. ಇಷ್ಟು ಮಾಡಕ್ಕೆ ಎಷ್ಟು ಬರ್ಬೇಕಾಯ್ತು ನಮ್ಗೆ? 60 lakhs plus interest ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ?
The first 30 days was 80%. And for the after 30 days was up to 28.6 that happened. 21%.
28.6, sir. ಇವತ್ತೇನು ಡೇಟ್ ಸರ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಇನ್ನು 10 ದಿನ ನೀವು ಕೊಡ್ತೀರಾ 10 ದಿನ ಒಂದಿನ ಆಗ್ಲೇ ಇಲ್ಲ ಅಂದ್ರೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀರಾ ನಿಮ್ಗೇನು ರೂಲ್ಸ್ ಅಪ್ಲೈ ಆಗಲ್ವಾ ಟೋಟಲಿ ಅನ್ಫೇರ್ ದಿಸ್ Suraj Patil, Learned Counsel for Respond number 1 and 2, has today handed over a demand draft for an amount of 78,38,367, bearing number 573792, dated 1/7/22, drawn in favor of the petitioner in full and final payment of the amounts due by the Respond number 1 and 2 to the petitioner. He submits that the said amount comprises of 18% interest on the first 30 days on the principal amount of rupees 60 lakhs and interest calculated at 21% for the remaining period until 28/6/2022. Learned Counsel for the petitioner accepts the said demand draft and in view thereof he submitted his grievance has been addressed and therefore the writ petition may be disposed of. Accepting the said submission, the writ petition is disposed of. However, it is observed that it is for the BDA to verify from its records wherever payments have not been made to persons similarly situated like the petitioner and to immediately make payment of the same. Counsel for the petitioner has filed a memo dated 24/2/2022, signed by the first petitioner for self and as special power of attorney holder of all petitioners, as also by the counsel for the petitioner. The petitioners have stated that they do not wish to prosecute the above matter and as such seek permission to withdraw the same. Accepting the said memo and the submission made by the counsel for the petitioner, the petition is dismissed as withdrawn. Now, what liberty can we do? If there is some order to challenge, we can do, not a yes. For what? That commercial and residential, yes. Right side of the commercial is ತೆಗಿಬೇಕಾಗಿ.
Commercial building
Yes.
So again, open land for future development, commercial, residential, belonging to investment.
What is this you are doing, Mr. Counsel? So you do what you want in the future development. Why are you showing in this plan? It was made very clear to you. Are you trying to overreach the orders? We will pass over. Please ask Mr. Shetty to come. We don't appreciate this kind of thing. This is the third time the matter is being adjourned for this reason. Also. Yes, Mr. Krishna? Mr. Sebastian?
I pray for the second respondent, please, my lord. I pray for 2 weeks' time to file my objections because the petitioner has suppressed the material facts about the case.
You are
This
now
is for-
appearing for the society.
Society, yes,
You are
please.
appearing for the society.
Yes, my lord.
M.A. Sebastian, counsel for respondent number 2 seeks for and is granted 2 weeks.
2 weeks, please.
2 weeks time to file his objections. Objections, if any, by 21st. Relist on 26th.
Much.
My lord, I am appearing for petitioners in this matter, my lord. My lord, the
Petitioner is
original
expired.
petitioner died on 10/2/2020.
We will allow the application to proceed. During the tendency of the above matter, the sole petitioner expired on 10/2/2020. In view thereof, IA 1, 2, and 3 of 2022 have been filed on 16/6/2022. IA 1 of 2022 has been filed for condemnation of 833 days in filing the application. Accepting the reasons stated in the affidavit in support thereof and being satisfied with the same, taking into consideration that the right to sue survives and continues. The delay of 833 days is condoned. IA 1 of 2022 is allowed. The abatement in respect of deceased petitioner is set aside by allowing IA 2 of 2022. By allowing IA 3 of 2022, the persons named therein are brought on record as legal representative of deceased petitioner as P1, petition number 1A to petition number 1B. Counsel for the petitioner to carry out necessary amendment and file amended clause title within a period of 1 week from today. Mr. Krishna, you haven't filed objections? You have filed? Now file, madam. Either. Relist on. Hearings being complete, relist on 19/7 for final hearing.
Much obliged.
One and two, you want to withdraw. Okay, why? What is the liberty? So truncated this stuff. She B.S. Radhanandan, learned counsel for the petitioner, seeks permission to withdraw IA 1 of 2020 and IA 2 of 2020 with liberty to file fresh application with additional documents and additional pleadings. Accepting the said submission, IA 1 of 2020 and IA 2 of 2020 are dismissed, reserving liberty as aforesaid. Then dispose out within period of 8 weeks until that. ಮತ್ತೆ ಇವಾಗ 8 weeks ಅಲ್ಲಿ ಅಂದ್ರೆ ಯಾವಾಗ ಮುಗಿಯುತ್ತೆ 8 weeks? What we need to dispose of. So ನೀವು ಯಾವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀರಾ? ನೀವು ನಾಳೆದು ಹಾಕ್ತೀರಾ? Shri B.S. Radhanandan submit that you will be filing the applications by 6th of July 2022. Shri K. Krishna seeks for and is granted 10 days time. Mainu Akilva. By 8 July 2022, Shri K. Krishna seeks for 2 weeks time thereafter to file his additional statement of objection. Additional statement of objection to be filed on or before 22nd July. Relist on 26th July. 26th July, please get ready for hearing. ಏನಿದು ಕಲ್ಯಾಣ್? ನಾಗಭೂಷಣ ಅವ್ರು ಬಂದಿಲ್ವಾ? ನಾಗಭೂಷಣ ಅವ್ರು ಬಂದಿಲ್ವಾ? is well now. That counsel for the Village Kandon and Madala. The counsel for the petition seeks for and is granted. A week's time, readers from 12/7.
Both these repetitions in the law are by the authorities of the previous side 22 years back. 22 years back, they have made the entire statement situation. But landlords have filed some cases. We fought the BDA along with the BDA, and now it is concluded. These sites have been allotted to these defendants, respondents. When the site is not cancelled, no notice is issued. Even today, it is in the registers. Last 22 years. One is a soldier, the other is a defense.
Counsel, respond number 2 is stated to have expired.
Yes, we have not the loss.
You sought time to file necessary application to bring the legal representative respond number 2 on record.
Yes.
This was on 7/6.
Yes.
We don't see any application having been filed.
Applications.
When did you file the application? No, service is complete ಆಗಿಲ್ಲ. What we have made a note is that you will file necessary application and also file objections to IA 2 of 21. Neither are objections filed nor is the application filed. Before we get to the merits, you have to close these issues. The applications. We will come to that a little late. Anything related to 460/49? First, either close ಮಾಡೋಣ ಆಮೇಲೆ ನಿಮ್ಮ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತದೆ. ಇದೆ ಅಪ್ಲಿಕೇಶನ್ಸ್. ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ಲ.
Previous counsel said he will appear. That's what, because we didn't know the law. He said he will make an application and appear.
Who is respond number 2, Mr. Shankarappa? Mr. Shankarappa? Okay, now he has not filed. So what do? We dismiss it against R2.
Yes, it's our. Yes, because on the last occasion, such a submission was made. We came here with the impression that they would
They will file. So you are new ಮಾಡಬೇಕಾಗಿದೆ.
And take steps.
No application has been filed. 22. No application has been filed to bring the legal representative receive respond number 2 on record by the counsel earlier appearing for respond number 2. Hence, counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application.
I don't know, I am myself guilty because 22 years, in fact, I'm adding to all these, I think in fact, I wanted to make a very fervent appeal to this court.
As a senior counsel, you would not know what is happening in the administrative file of this.
Yeah, they came and reported to me that the council came and he said he would develop.
What about objections to IA2 of 2021? Since no objections have been filed to IA2 of 2021, objections. You hold your horses, Mr. Kalyan. You are not there in the first matter. Objections to IA2 of 2021 has not been filed. Objections are taken as nil. In terms of IA2 of 2021, additional facts and additional prayer are sought to be brought on record. Being of the opinion that the same is required for effective and complete adjudication of the matter, IA2 of 2021 is allowed. Counsel for the petitioner to carry out. ಯಾವ objection? ಯಾವ objection? ಒಂದು first ಮುಗಿಸೋಣ. Counsel for the petitioner to carry out necessary amendment and file amended writ petition within a period of 2 weeks from today. Yes, now we come to 22.1. What is this? Yes, Mr. Kalyan, what did you want to say in this?
Was acquired by CH-21 as after fighting for almost 45 years before. Finally, when the contempt petition was filed, they undertook that they will execute the reconveyance entry. Subsequently, they said that the site is required for their own use and said that to assure that they will give alternate site. As an alternative measure, they have given the site and the portion of the site is subsequently sold.
Now, why were these two matters connected?
They are both of them are neighboring sites, and both of them were allotted under the same allotment notification 22 years back. Both of them were parties before the litigation for 20 years. But in both the cases, the allotment is order is there, and then the entire payment has been made. The entire both in these facts and circumstances are identical.
But the property is different. So in this one, IA2 of 21 has been filed by you again.
Yes. I sought for, I completed the existing authority as additional district registrar. And consequent upon that, my lord, suitable changes have been made.
That impleading is done. Amendment IA2 of 21,
Yes.
Same amendments.
Yes.
Further relief. Orders on IA2 of 21, 22.1 has been filed to place certain facts and the additional prayer on record being satisfied so and so. Allowed. Counsel for the petitioner to consider that. You want to file any additional objections? Either additional objections you have amendment allowed, you want to file additional objections, if any, by the respondents as regards the amendment allowed within a period of 2 weeks from today. File Madia. File Madia. Illalla. Released on 26/7. amendments carry out ಮಾಡಿ ನಿಮ್ಗೆ ಏನು
Access to make a very permanent plea. 22 years is a long period. Two of them have died, and in fact they are also they are not sure, they don't want to leave the legacy to their children.
But ಇನ್ನ ಇವಾಗ 26th also we'll have to issue notice.
Yes. That's all right. We have nothing. Let them be 100 sites.
No, we will consider it on merits. Now, let us first get it ready to be considered.
Yes.
IA 1 of 2021 is allowed and failed. On the last date of hearing, IA 1 of 2021 was considered and allowed. And no further orders are required to be passed on IA 1 of 2021. Have you filed your objections? Yes. The pleadings are complete. Hence, IA 1 of 2022 is allowed. Relist matter on 12/7/2022 at 2:30 p.m. for final hearing. 12th and 19th. 19th? 2:30 p.m. We will dispose it over. The objections on the statement, Mr. Achappa? Kotra, copy Kotra. But one ನಿಮಿಷ ಅಲ್ಲಿಗೆ ಬರೋಣ. First, ನಿಮ್ದು what is this objection on your statement of objection? ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ದೀರಾ? ಸರ್ ಆಗಿದೆಯಾ? ಕಾಪಿ ಆಫ್ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲ, ಫಿಸಿಕಲ್ ಕಾಪಿನ ಕೊಡ್ರಿ. ಅವ್ರು ಪ್ರಿಂಟ್ ಔಟ್ ವಾಟ್ಸ್ಆಪ್ ಇಂದ ತಗೊಂಡು ಎಮರ್ಜೆನ್ಸಿಗೆ ಓಕೆ. Copy of the statement of objections has been served on the counsel for the petitioner. Hence, the objection raised by the registry does not survive for consideration. What is IA 1 of 2022? Accepting the reasons stated in support of IA 1 of 2022, the additional document is taken on, the said application is allowed, the additional document is taken on record. IA 1 of 2022 is allowed. Yes, you have filed your objections? Ready? Yes. You had submitted a domicile certificate, but not signed by the gazetteer. So only issue was duly signed by the gazetteer. What is your employment, Mr. What is the employment of the petitioner?
You're not getting the application.
On what basis do you say that he is an employee of the state government structure?
Let's go on to the days after the presentation to find out what this actual employment is, and that is also the interview. And the neighbors have witnessed that he is the government employee. When he is being asked whether he is government employee,
He is saying he is not. So if you are saying he is, where is he employed?
he is not disclosed that, and the neighbors have said that he is a government employee. Now, it may not, the other aspect is, one other aspect is, if they file an affidavit to the extent saying that they are not government employee, we conduct another inquiry into it and certainly ascertain the details and come.
Mr. Achappa, you are married? You can prove you are married. If somebody else is not married, can he prove that he is not married? You should have asked for it at that time. Why make him run to court? If you are saying it is not true, you should say why it is not true. When we say your entire proceeding is not correct. ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ಟು ಬಿಟ್ಬಿಡೋಣ ಇನ್ಮೇಲೆ ಆರ್ಡರ್ಸ್ BDA ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ BDA is not correct, full stop. Where is the statement of the neighbors? Did you take it on oath? We will give you a week's time, do that and get back. A week's time, not more. This application is pending from when? 2006. This is the application, not the petition. ಎಲ್ಲ ಹಿಂಗ್ ಕೊಟ್ಟುಬಿಟ್ಟು ಈ ಕೈಯಲ್ಲಿ ಹಿಂಗ್ ತೊಗೊಂಡರು. That reason does not stand, Mr. Achappa. If you are able to show that he is indeed working as a state government employee, we will direct initiation action against the petitioner. But if you are not able to show it, whoever signatures are there in that document that you are relying upon, we will have to direct the commissioner to initiate action against them. Then it is malified. Learned counsel for respondent number 1 and 2 seeks for the petitioner had applied for allotment of the EWS site measuring 20 by 30. Though the petitioner was allotted the said site, subsequently the same came to be cancelled by the BDA on the alleged ground that the petitioner has misrepresented himself and has suppressed the fact that the petitioner is an employee of the state government of Karnataka, and as such, the allotment was cancelled. It is in view thereof that the petitioner is before this court challenging the said cancellation. Shri P.V. Achappa, learned counsel for respondent number 1 and 2, submits that when an inquiry was conducted with the neighbors of the petitioner, the said neighbors had informed that the petitioner is a government employee. And it's on the basis of the said statement that the cancellation has been effected. So why was the cancellation?
because he has not produced the required documents.
It's cancelled. The counsel for the petitioner submits that by inadvertence, the petitioner had produced a domicile certificate signed by a district government leader, which ought to have been considered. Instead, the respondent contended that the same is not signed by gazetted officer and as such cancelled the sign. Shri P.B. Achapal and the counsel for the respondent submits that apart from the said cancellation, subsequently when an inquiry was conducted, neighbors informed also. On inquiry with Mr. Achappa as regards whether the statements of the neighbors have been recorded and their statements have been taken on board, he submits that he needs to obtain instructions. He submits that a fresh inquiry would be conducted and a report submitted within 1 week from today. Released on 12/7. One dina vote ಮಾಡ್ಕೊಂಡು ಬರೋದ್ರಲ್ಲಿ released on 19/7. Yes. What is the impeding application? Who has filed this? New file ಮಾಡಿದ್ವಿ. ಯಾಕೆ? Co-owner with the petitioner. Yes, Mr. Counsel.
Just received the original application.
If there is suit pending, until the suit is disposed of, who are these people to decide anything? I mean, suit ಏನು pending ಇದೆ? Suit ಏನಕ್ಕೆ pending ಇದೆ? Suit ಏನಕ್ಕೆ ಇದೆ? For meets and bounds. Where counsel for the petitioner seeks for and is granted a week's time to file objections to IA-1 of 2022, released on 19/7. There are no objection. What about the main petition? Objections on main to be filed by the respondent within the same time frame. Registry is directed to print the name of Shri T.V. Chandrasekhar as that appearing for the impeding applicant in IA-1 of 2022. ಏನಕ್ಕೆ? Where counsel for the petitioner seeks for a short accommodation, IA-1 of 2022 is allowed. Released on 19/7. So what the state to file 16 documents? Whether it can be allotted to, whether police station is a civic, Bari police station, Bari police station, police quarters, So what do you want to do now?
Anytime, there are 60 documents about the state government. I'll file the rejoinder.
The counsel for the petitioner seeks for and is granted 2 weeks time finally to file rejoinder to the statement of objection filed by the respondent. Rejoinder to be filed on or before 21st, released on 26th. Yes, Mr. Kadambi, how are you feeling now?
Wait, please. I am appearing in this matter on behalf of the petitioner. This is a Section 9 petition arising out of a software license agreement. Now, the respondents here are a British company and they have declared bankruptcy. I have filed a fresh IA 2 of 2022, where I have placed on record materials to show that now they have shifted their operations.
IA 2 of 2022.
Yes.
When did you file that?
This would have been, I filed it in January.
January. Yeah. We don't find it on record, madam.
I'll have it put on record. Would Your Honor have it in 2-3 days? Because what has happened in this case is that they have set up an American company with the same shareholders, and it's an alter ego. And I'm seeking the inclusion of that respondent in these proceedings. So if Your Honor would put it up any day next week, I'll have it.
IA 1 of 2022, is it for impleading?
Is that one? I'm so sorry. I have IA number 2 of 2020.
It's IA 1 of 2022 for impleading.
Yes. So this is IA. In this IA, along with the IA, I've placed on record materials to show that it's the same company with the same name, with the same shareholders.
Yes.
And this is an attempt to avoid the arbitration agreement. Now, my case.
What do you have to show that? Who are the shareholders in the
Yes. Would Your Honor just go to the annexure A?
Yes.
This is the same. It's the name of the company is Neural Space. And would Your Honor now see? Now, this is how on page 17. Your Honor has page 17.
Yes.
So on the bottom of page 17, it says main office and it gives a London, UK address.
Yes.
Now, subsequently, after this petition is filed, the website is changed and the revised address Your Honor would find on page 24. Then Your Honor would see.
Yes.
Page 36.
Page 36.
36 is the team. And Your Honor would compare it to page 34. Page 34 and page 36. So the three individuals are the same between the British entity and the American entity. I have taken page 34 from the Companies House website in the UK, and page 36 was their website.
Yes.
And page 37.
Hello.
Gives the incorporation details of the proposed respondent number 2.
Hello.
This shows it is in Delaware. That till now you've been saying.
I'm so sorry. I'm so
Now
sorry.
it is saying it is Delaware. This is a registration in Delaware.
Yes, they have now registered in Delaware, and I can show Your Honor the judgments on alter ego. That basically, when a company
we'll come to chloro control later. But on page 37, this is something registered in Delaware. Okay,
yes.
You want to show that the address is now United States.
Yes.
What is the address here? United States, Delaware. Now it's a Delaware registered company.
Now it's moved to Delaware.
Okay.
And Your Honor may see the date of incorporation. This is. Your Honor, see it is 15th July 2021, after I raised the dispute with them. The sum and substance of my case is that under the software license agreement, they were to exclusively supply to me certain software, and they have breached that exclusivity. Therefore, I sent them a notice and then subsequently filed the Section 9 petition, and I was given a status quo order.
What is the relief that you are seeking for here?
I am seeking, I'll just show you. In the IA, Your Honor is asking me, or in the main petition?
In the main petition.
In the main petition, I'm seeking that they be restrained from supplying the software to anybody else. It's a prayer for injunction, which Your Honor will find at page 19 of my petition.
Our proceedings have been initiated?
Not yet, Your Honor, because they've gone into liquidation. There's no way I can actually initiate effective arbitration proceedings against them. Because Your Honor may see their reply. They filed a response saying that they don't have anything. They have appointed.
The manner in which you have invoked Section 45.
Yes.
And saying that they are a group company or alter ego or a group of companies.
Yes.
You could have initiated arbitration on that. Because this petition is pending from 13 September 21.
I need them to be included for the purpose of only I need the interim order to be extended to them. That is my difficulty, because today.
Madam, the difficulty that this court is facing is the interim order which is granted is there's an interim relief.
Yes.
Subject to a final outcome of something.
Yes.
Now, if you are saying you are unable to initiate arbitral proceedings, and you won't initiate arbitral proceedings because you can't initiate against the respondent, then this order will be in perpetuity, which cannot be.
No. All I'm asking is that they be asked to take a stand, because today what is happening is that they are, in my respectful submission.
What we are asking is for you to take a stand, because you are the petitioner.
No,
are you going to initiate arbitration or no?
We, of course, definitely we are, but because this is an intellectual property dispute, what we don't want is an other entity being set up, a third entity, because then what happens is, which is what the alter ego doctrine really seeks to preempt, is that they keep running from entity to entity. Now, to move from country to country is not a small matter. They've done it. Now, today, when I file a arbitral proceeding against the US entity, there's no guarantee that my rights will be protected in the meanwhile. They can just transfer the technology. I'll be left without a remedy.
Your application was filed for impleading on 4/1/2022.
Yes.
We are now in July 2022.
Yes.
More than 6 months.
Yes.
What have you done in 6 months to establish your bona fides?
Your Honor, what we've done is we've sent them a legal notice in the US. I've not put that on record here. We've sent them legal notice, to which we've received no response.
Now, please initiate arbitration. We are not satisfied with this.
Your Honor would just allow me. No, Your Honor would then give me some protection in the interim, because without that,
no, your earlier protection will also go, because we are not satisfied with your conduct.
No, Your Honor, what I have done is that I have
As per sub-rule 4 of rule 9 of the Karnataka arbitration rules, you have to initiate within 90 days. You filed the proceeding on 13 September 21, obtained a status quo, not initiated arbitration, not initiating arbitration even today.
Your Honor, my hands are tied only because there is no effective way I can initiate against.
So our hands are also tied, madam, because you are not going to initiate.
Your Honor, just give me an opportunity. 1 week, I'll satisfy Your Honor. I'll present my case before Your Honor. Your Honor may not pass any effective order disposing of this application, because it can be transferred at any time. And I'll place on record the legal notice I've sent them, to which I've received no response, to the US entity.
Please understand, your application itself is pending for 6 months without any order.
Your Honor,
now you are pleading urgency.
Your Honor, all I'm saying is let notice be issued. I'm not asking for let notice be issued.
We are not satisfied with it. Please satisfy us on it.
Would Your Honor just put it up in next week anytime?
Counsel for the petitioner seeks for and is granted a week's time. Bail is on 12/7 at 2:30 p.m.
I'm ready.
Thirty-one ಅವರು ನೀವಲ್ಲ Yes, Mr. Chandrasekhar. Something is pending in writ appeal ಅಂತ ಹೇಳಿದ್ರು. ಏನಾಯ್ತು? That was on 31st ನೀವು ಹೇಳಿದ್ದು. ಅದು ಹೋಗಿದ್ದವರು 23rd ಹೋಗಿ 31st ಗೆ ಹೆಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಾ? 31st ಆದ್ಮೇಲೆ ಹೋಗಿಲ್ಲ ಅಲ್ವಾ ಮಿಸ್ಟರ್ ಚಲ್ತಿ? ಮತ್ತೆ ಬೆಂಚ್ ನ್ಯೂ ಬೆಂಚ್ has to be parted. ಅಂದ್ರೆ we'll have it in September. You are putting us in a very difficult position. We list on, at the request of both the councils, we list on 16/8. Mr. Ahmad. Petitioner is before this court seeking for the following relief. A coordinate bench of this court in WP number so and so is dealt with matters relating to the allotment of sites and cancellation thereof. And as in terms of para 61(9), refer the matter to a committee constituted by the said coordinate bench. Hence, I have the considered opinion that the above matter would also have to be referred to the committee. Hence, I pass the following order.
And for the petition in this case, my lord.
Yes.
My lord, this is the case where I have challenged an endorsement issued by the BDA at Annexure J, lordships. A flat was allotted to the petitioner herein in the year 1970.
Just one moment.
Yes, yes,
ಎಲ್ಲಿದ್ದಾರೆ ವಚನ? Pass over. You want a pass over? You are ready?
Yes, I'm ready in this matter. 2:30, lordships.
Mostly 2:30 now. ವಚನ pass over, Mr. Vachan is on his feet in another courtroom. You are ready, Mr. You will address? Objections are filed. Either. On 1921. Same pass over or adjournment? Mr. Inde? Next week, 37 and relist on 12/7. You are appearing for 1 and 2. Mr. Jagdishwara, ಇವತ್ತು ಇಲ್ಲ. ಒಂದು ನಿಮಿಷ. State Council for R3, Mr. Charity. The State Council and a new idol. In BMIC of you, State Council and the cause list. State Council and it's only BBMP. And Mr. Jagdishwara is not here. We have anyway said that if he doesn't appear, we will take it. Page?
Page 253.
253. Yes.
Regarding demolition of unauthorized structure, kindly mark survey number 30/1. So this is the subject matter, but if they say, Lord, I am an unauthorized occupation, therefore they would like to report that my specific sentence is not before my lordship. That I have not purchased Lord any land Lord which bears this agreement. I have produced the copies of the Lord Sale and Joint Development Agreement, which bears Lord the Khata of the Khata numbers, not survey number. Lord, all these survey Lord the lands which I have produced Lord kindly see Lord annexure Lord page number 3 of my produce.
This Khata has been issued by A Khata, B Khata.
But they are all Gram land.
So then it's some survey. Then what is the survey number in which it is situated?
They are all the old village. Page number 7. These are the Khata numbers.
Mr. Chandrasekhar, you would have done title due diligence. Tracing of title, Elinda Bantu, Yav survey number in the Bantu.
That is our case. I have purchased the property which bears the Kanishmari number.
Kanishmari number.
Page 7 you will have to be paid.
So where is the tracing of title in the JD?
No, I have produced the sale deeds and joint development.
Really the sale deed?
Amalgamation Khata, corporation has given.
Sale deed in the page number?
Page 280.
218.
Amalgamation is also done.
No, you have to come clean on which survey number this property is.
Watching here for a moment. Now kindly see what the case of the respondent. I will be able to demonstrate what this is not the property which is acquired by the we cannot make any claim. Apart from the content.
Like we don't even know what is your property. That's a property.
Now
Khata number kotre, we can't correlate it to any survey number.
watching here for a moment. Now kindly see what the case of the respondent. Which they say, Lord, this is the property they would like to demolish and take the property into their possession, alleging that I am in unauthorized occupation.
Now they want to demolish in 30/1A. Yes. So you will have to show us that you are not in 30/1A.
But this is not being acquired, Lord, I will be able to demonstrate, Lord. Now kindly see, Lord, the objection statement, Lord.
Acquired by for what?
Acquired for Lord, formation of residential layout. Formation of the school and conduction of road.
Rolled or layout? HSR layout.
Annexure R6 by kindly.
R6. Okay. Yes.
The marked portion page 77 of the object.
Yes.
They said, Lord, this is the land in question, but they would like to demolish and take possession of the property. Remark 4.
Yes.
30/1. Now, my Lord, I request my Lord to kindly see the final notification. My Lord will find at page number 29. It starts, my Lord, from page number. Next year, R1, my Lord, page 8. Relevant page, my Lord will get my Lord at page number 29.
Yes.
At serial number 195.
Yes.
195. 30/1A.
Yes.
Measuring 1 acre 17.
Yes.
Is the land that is notified my Lord under the bylaw. Then your lordship will kindly see Lord the copy of the award which they have produced Lord. Relevant portion your lordship will kindly see Lord at page 64.
64. Yes.
It starts Lord from page number 57. The relevant portion Lord. Now kindly see Lord at page 57. Sir.
64 last year 2 acres 25 guntas and 30/1A antar. Page?
Page 57, first page of
57. Yes.
Survey number 30/1A, Lord. They say, Lord, 2 acres 25. My lords have already seen, my Lord, what is acquired in 1 acre 17 because at page number 29.
Yes.
Now, my Lord, they say, my Lord, the final notification, my Lord, this endorsement, my Lord, government order, my Lord, is for 2 acres 25. Now, kindly turn to, my Lord, the award passed by the land acquisition officer at page 64.
Yes.
The land is urgently required by the BD for formation of the river between Hosur Road and Sadapur Road. Hence, I hereby acquire the land measuring 2 acres 25 meters, each survey number 30/1 of so and so. The final notification itself is for 2 acres 17 meters.
But who are you, Mr. Chandrasekhar?
No, notice is now given to me, my Lord, asking me to, my Lord, demolish. This notice issued to me.
Have you challenged the acquisition?
This is not at all acquired, my Lord, even according to them. Now the notice is given to me as per election.
Your contention, from what we understand, correct us if we are wrong, is that the final notification is for 1 acre 17 meters, but the award has been passed for 2 acres 25 meters. It could not have been passed for 2 acres 25 meters. So it is
bad.
bad.
I am now trying to say, I have come before this honorable court saying, my Lord, I have purchased the property, my Lord, which bears the Karnataka number. This property was not at all subject matter of acquisition at any point of time.
So which survey number is your property, Mr. Chandrasekhar? Which survey number is your property carved out of?
But kindly see, my Lord, Annexure C, my Lord, in the petition, amalgamation Kharta is given by the corporation. Page 247. They give survey number. But we are saying, Lord, Khana.
Chandrasekhar will ask you for the last time. We won't again ask you that question.
But I do not, but I have not purchased the property which bears the survey number.
So then you have no
I am
notice.
not in a position to say, my Lord, which survey number, my Lord, these, my Lord, because they are.
So they will demolish what is survey number 30/1A. You cannot have any
to the
grade.
extent of 2 acres 17.
Whatever they want to do, you have nothing to do with that survey number. Why are you bothered?
Now they are coming to my, Lord, physical position of my property and identifying it as, my Lord.
As we said, we won't ask you again. If you are not in survey number 30/1A, it won't make any difference. Because you are not coming clean.
But I am claiming, Lord, in respect of, Lord, this.
Khata number. Please claim. Please keep claiming on the Khata number if you are not coming on the survey number. You know what we are speaking of. Unless you come forth and say that If you accept it, you will have to challenge the acquisition. You don't want to do it. All villages are there, and those villages are the ones which are acquired for all these purposes.
These survey numbers disappear once the village is established, and Khata numbers are given, and the taxes are being collected on the basis of the Khata. So we would like to say that this is a survey number, which is not at all in existence, and they want to come and
your joint development agreement and safety is very silent about the tracing of the title. Nothing is mentioned. It is completely malified the way it is mentioned.
We have not mentioned survey number because it does not give survey.
Who used to own it? Who transferred it to whom? What happened? When did they purchase? Gift deed dated 24/9/2012. Adrinda eno 2012 andre acquisition aadmela.
Corporation has verified our property. They have amalgamated this land into several other, and thereafter the Khata certificate is given.
That will issue separate directions on that, but you are not able to establish any case for your matter.
Kindly see the next page
247. At the total, no. Khata numbers.
Now, what the sketch is produced, my lord, the sketch indicates my property.
Where does it indicate your property?
Lord, that is what they have stated.
Khata number ellide.
Khata number ಅವರು ಹಾಕಲ್ಲ.
ನೀವು ಸರ್ವೆ ನಂಬರ್ ಹಾಕಲ್ಲ.
ಸರ್ವೆ ನಂಬರ್ ಇಲ್ವೇ ಇಲ್ಲ.
ಆಯ್ತು.
They come and spot on the property and say, "Lord, I have demolished." They have also made a statement that they have demolished and taken possession.
At some point of time, there had to be a survey number. If you don't trace it, then we can't help you. They are not coming free.
Statement of the PDA itself, what is acquired is only 2 acres 17.
You are nobody to say that because you have nothing to do with that survey number. Until you claim some connection to survey number, you are nobody to make any statement as regards survey number.
May I make it in this way? Statement. They have identified the property which, according to the BDA, falls within the layout formed by them, which is alleging to be 31 bar game. According to their own showing, 31 bar game is acquired only to the extent of 1 acre 70. If that is the case, they cannot pass an award in respect of a larger extent of the land, and try to trace their position in respect of a larger extent of the land.
Yes.
If the sketch indicates my land, I have a right before my lots contained in let them not interfere in more than 200 or 1 acre 17 and my Khata.
Yes.
I say, Lord, this property which they have indicated in their sketch, and they are coming to my property saying that it belongs to them, Lord. My responsible submission is, Lord, my land is not being acquired. They are, anyway, Lord, if they are owner of the property, Lord, it is beyond the road. Kindly see, Lord, once again.
No, for that you will have to first admit that you are in 30/1, which you are not admitting. So we can't help you, Mr. Chandrasekhar.
Kindly see, Lord.
Because you are saying your property is different from this.
My property is beyond the road.
We can't help you.
But kindly see, Lord, once again, Lord, I will probably kindly see, Lord, page number 77 once again. This only piece is beyond the layout form. Road is already. Only this piece of land road is beyond the road. Page 77.
We can't help you, Mr. Chandrasekhar. Because your client is trying to be smart. That over smartness is killing him. If he comes to court with clean hands, the court will be of assistance to any litigant. But if a litigant is trying to pull wool over the court and everybody,
I will not make any further argument on this. I will ask Lord advocate on record to find out if he can trace this survey number.
No, we won't give you any time. Enough of documents have been created for this purpose. We understand why it has been created after the notification, after the acquisition, after formation. And this is only to circumvent the whole process. So we'll impose cost. dismiss the petition.
But notice is issued to me.
Yes. You are an unauthorized occupation. You have no right on that.
But I have been able to show that their acquisition is only to the extent of
We will deal with it. We will deal with it. Petitioner is before this court seeking for the following release. The petitioner claims to be a partnership firm engaged in the business of construction and alley activities. Petitioner had entered into a joint development agreement. Had entered into joint development agreements dated 4/9/2014, 27/9/2014, 24/11/2014, 14/1/2015, and 16/1/2015 with the alleged owners of the said lands for purpose of residential development. Owners of the land covered under Tanishmari numbers, page 7 and 1 to 12. It is further alleged that the petitioners had also purchased some of the said lands from the earlier landowners. In pursuance of the aforesaid joint development agreement, the petitioners had approached the Brihat Bangalore Mahanagarpalika (BBMP) respondent number 3 herein for amalgamation of Tata covered under the aforesaid joint development, aforesaid several joint development agreements. Accepting the said request, the BBMP amalgamated the Tata and issued a letter dated 24/8/2017, bracket Annexure C. Thereafter, the petitioner moved an application for building license, and a building license also came to be issued. The petitioner had erected a temporary shed and a site office in the said properties. It is at this stage that the respondent number 1 BDA had contended that the petitioner has encroached upon portions of property belonging to the BDA and as such called upon the petitioner to remove the construction and vacate the property. Pursuant thereof, a notice came to be issued under Section 462 of KMC Act and 33(2) of the BDA Act on 28/8/2017, calling upon the petitioner to remove unauthorized structure in survey number 30/1 A and the compound on survey number 3/2 of Ellikunte village, Begur Hogli, Bangalore South Taluk. In pursuance of the authorization received from the Commissioner as also the resolution of the authority, the Bangalore Development Authority, bearing number 2025 dated 12/3/1991. It is agreed by the same that the petitioner is before this court seeking for the above reliefs. Shri S. N. Chandrasekhar and Senior Counsel would submit that the notice which has been issued is as regards survey number 30/1A and survey number 3/2, which is no way connected to the property of the petitioners in Tata numbers so and so. Therefore, he submits that the notice is bad in law and is required to be quashed. Apart therefrom, he submits by relying upon the objection statement filed by the respondents that the respondent had acquired land measuring 1 acre 17 guntas in survey number 30/1A, and an award has been passed subsequently on. What is the date of the award? Final notification date.
Final notification dated 28/11/1986.
Final notification date 28/11/1986. 28/10/1986. And the award has been passed on.
There are two awards.
E award, yeah, page 64.
3/2, 22/8/1987.
30/1A.
1A up to 5,980.
ಎಲ್ಲಿದೆಯಪ್ಪ ಡೇಟು? Where is the date? 64. Signature 17-3 ಇದೆ. Deputy Commissioner approval is 10-5. Award had been passed on 17-3-1988 and approved by Deputy Commissioner, Bangalore Development Authority on 10-5-1988 for an extent of 2 acres 25 guntas in survey number 30/1A of Elikunte village, Bangalore South Taluk. Relying on the same, he submits that the acquisition of the land under the final notification being only for 1 acre 17 guntas, there could not have been an award passed in respect of 2 acres 25 guntas. Hence, the claim of the BDA that the land has been acquired is fallacious, and as such, the notice which had been issued is required to be quashed. Shri B.S. Sachin, Learned Counsel, appearing for respondent number 1 and 2, would however submit that the land where the petitioner has put up the construction is situated in the land which has been acquired, and the petitioner having no right over the said land, the respondent has rightly issued the notice since the construction has been put up on the land belonging to the respondent. He therefore submits that the petitioner, relying upon Tata numbers, when the survey numbers have been acquired way back in the year 1988, is completely malafide and the petition is required to be dismissed. Third, Shri S.M. Chandrasekhar, Learned Senior Counsel, appearing for the petitioner. Shri B.S. Sachin, Learned Counsel, appearing for respondent number 1 and 2. None appears for respondent number 3. This court, while its order dated 21/6/2022, had observed that even if none were to appear for respondent number 3 today, the matter would be taken up for consideration in their absence. It is in that background that the above matter was taken up. Correct. The petitioner, as aforesaid, claims to be yes, no dispute about that. Already we have covered that. The contention of the petitioner is that the petitioner has entered into joint development agreements and or purchased several land covered under several Tata numbers. In persons of the same, the joint development agreement and sale deeds have been produced. A perusal of the joint development agreements indicates that there is no tracing of title which is occurred except to trace it to the year 2012, where the owners are said to have acquired title under a gift deed dated 24/9/2012. Though there are 5 joint development agreements which have been entered into, in none of the joint development agreements, the original owner's name or any tracing of title has been mentioned. It's a gift deed in the joint development agreement dated 4/9/2014. Tracing of title is to the gift deed. In the joint development agreement dated 27/9/2014, except to state that the owners are the absolute owner of Tata number, there is no tracing of title deed. In the joint development agreement dated 24/11/2014, once again, apart from referring to a partition deed dated 7/5/2014, there is no tracing of title made in the document. In the joint development agreement dated 14/1/2015, except to state that the owners have acquired the same under partition deed dated 4/4/2014, there is no tracing of title. in the joint development agreement dated 16/1/2015, except to state that the owners of the property having acquired the property under partition deed dated 4/4/2014, there is no tracing or title of the property. In the absolute sale deed dated 14/1/2015, the manner of acquisition of title has been shown as a gift deed dated 28/2/2014. In the absolute sale deed dated 1/4/2015, the manner of acquisition of title has been shown as a gift deed dated 19/1/2015. In all the aforesaid joint development agreements and absolute sale deed, the properties are described as Khata numbers without tracing as to from which survey numbers the said property is derived from. Needless to say that any particular property where a Khata number is issued is always traceable to a survey number. The respondent has produced a notification, final notification, dated 29/10/1986, wherein there are several lands, including the lands under survey number 30/1A, measuring 1 acre 17 guntas, was acquired. The acquisition having occurred in the year 1986 is not in dispute. The award which has been passed in the year 1988 is also not in dispute as adverted to above. The documents that have been relied upon by the petitioners have come into being in the year 2012 and 2014, which is much after the acquisition and the award. Shockingly, the petitioner who claims to be involved in real estate business, the documents do not even trace out the title of the property as to who was the original owner, what was the extent of land owned by the original owner, etc. In that background, I am of the considered opinion. However, while addressing arguments, Sri S.M. Chandrasekhar, learned senior counsel, by referring to the final notification as also the award, would contend that the extent of land acquired under the final notification being only 1 acre 17 guntas, the award could not have been passed for 2 acres 25 guntas, and therefore he submits that the acquisition is bad. The petitioner not laying any claim over survey number on account of the fact that the difference between 2 acres 25 guntas and 1 acre 17 guntas, the acquisition is invalid. There is no the acquisition is invalid. The acquisition, there was no acquisition, and therefore no award could have been passed. I am unable to accept the said submission of the learned senior counsel for the simple reason that there is no claim laid by the petitioner as regards either survey number 30/1A or 3/2 of Velatunte village. The only claim laid is as regards certain Kaneshmari numbers or Tata numbers. Kaneshmari numbers allotted by the Panchayat and the Tata numbers allotted by the BBMP. As of a said, the documents on which basis the joint development agreement and the sale deeds have come into being are gift deeds of the year 2012 and partition deed of the year 2014, which is much after the acquisition. In that background, I am of the considered opinion that the petitioner are seeking to suppress the facts by not tracing the title to the concerned survey numbers, which the BDA has contended that it relates to. And this suppression and deliberate suggestion of false facts relatable to the Tata numbers is a complete abuse of the process of this court and is only to reopen the acquisition which is already complete. Correct. The petitioner who has no right or who does not claim any right as regards survey number 30/1A cannot refer to either the final acquisition notification or the award to contend that there is no acquisition in respect of land. The difference between the land of 2 acres 25 guntas and 1 acre 17 guntas. Hence, I am the considered opinion that there are no grounds which are made out and the petition is required to be dismissed by imposing exemplary cost. I quantify the cost at ₹5 lakhs payable by the petitioner to the Karnataka State Legal Service Authority within a period of 2 weeks from today. Correct. In view of the peculiar arguments which have been addressed by the petitioner as regards the differentiation between Kanishmari number, Kata number, and survey number, I am the considered opinion that further directions are required to be issued to the concerned authorities so that this kind of confusion is not created in future. Correct. It is therefore required for the state government to consolidate and cross-reference the Kanishmari numbers, Kata numbers, and survey numbers, and if necessary, the municipal numbers as and when allotted, so that there will always be a cross-reference from the survey number to the Kata number or Kata number to the survey number. In this regard, the Chief Secretary, Government of Karnataka, is directed to coordinate with the Revenue Department, the Urban Development Department, municipal authorities, municipal corporations to arrive at a single dashboard where all these details are collated and cross-referenced by taking the assistance of the e-governance department. A report, a proposed action report to be submitted within a period of 4 weeks from today. In view of the above, I pass the following order. The petition is dismissed. Petitioner is directed to make payment of cost of ₹5 lakhs to the Karnataka State Legal Service Authority within a period of 2 weeks from today. Though the above petition is dismissed, the relist on 26/8/2022 to enable the Chief Secretary and or Secretary E-Governance to file a report of compliance.
Pray for the respondent, Your Lordship.
Yes. You're fine. Hagadre parvagilla, if somebody else is appearing. Shri Vishnath HM files a memo of retirement dated 5/7/2022. The said memo is accepted and is discharged from the matter. Srimati, whose name will have to be shown in the cause list? Whose name has to be shown in the cause list? Mr. Yeshu Mishra has entered appearance for the petitioner. Your file wakalat? Registry is directed to print his name as that appearing for the petitioner. Objections hakidira, Mr. Kiran?
Yes, Your Lordship. Objection has been filed. Your Lordship, the writ petition is not
being
filed.
complete, released on 19/7/2022 for final hearing.
Much obliged.
Mr. Bhatt,
I appear
any
for the
question?
respondent, my lord.
Yes.
41.
Yes.
My lord, this petition would not be maintainable because the petitioner sought for relief against the BDA.
One ನಿಮಿಷ ಏನೋ Mr. Bhatt. ಇನ್ನ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು Mr. Bhatt? 2017 matter. No, we are listing all these old matters so that those could be disposed. We'll give you one more opportunity. Adadmele matte Learned counsel for the petitioner seeks for and is granted 2 weeks time finally to address his arguments, released on 19/7 at 2:30 p.m. ನಿಮ್ದೇ ಮಿಸ್ಟೇಕ್ ಅಂದ್ರೆ ನಾವೇನ್ ಇವಾಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಯ್ತಲ್ಲ, ಸೊ ಆರ್ಡರ್ ಅಲ್ಲೇ ಹೋಗುತ್ತೆ. ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡೋದು ಬೇಕಾಗಿತ್ತು. Following our direction and another matter, the Chief Secretary has also issued a circular to all government departments, all statutory bodies, all secretariats to register. So everybody will have access to the orders immediately. ಅದಕ್ಕೆ ಒಂದು ಆ್ಯಪ್ ಕೊಡ್ತಾರಂತೆ ಒಂದು ಫೋನ್, ಎಲ್ಲಿ ಹೋದ್ರೂ ಸಿಗ ಆಗುತ್ತೆ. ನಮ್ದು ಹೈಕೋರ್ಟ್ ಟೆಲಿಗ್ರಾಮ್ ಚಾನಲ್ ಮಾಡ್ದಂಗೆ ಅವ್ರು ಒಂದು ಟೆಲಿಗ್ರಾಮ್ ಗ್ರೂಪ್ ಮಾಡ್ಕೊಬೋದು, ಎಷ್ಟಾದ್ರೂ ಹಾಕೊಂಡು. ನೋ ಲಿಮಿಟ್ ಲೈಕ್ ವಾಟ್ಸ್ಆಪ್ ಆಫ್ 512. Shri Murugesh Reddy, Learned Counsel for Respondent number 1 and 2. Submit that by inadvertence he is not able to obtain instructions as regards the orders dated 21/6/2022 and 19/1/2021. He seeks for and is granted 2 weeks finally to make his submission, released on 19/7. First respondent name, Mr. Krishna. You are but first respondent. Niva. Shri K. Krishna, who is you BMRC alidira. So conflict interest was new barakagala.
Respondent BBMP method.
4 and 5 years. Shri Vivek Yavagal is no longer on the panel of the Bangalore Development Authority. Hence,
in this case, I am appearing for BBMP on behalf of Puttaigoda, sir. The copy of petition is not been served, madam.
Petitioner illa, madam. Petitioner would
Please.
The NAIFA is directed to accept notice for respondent number 1. Registry is that delete the name of Shri Vivek Yavagal as that appearing for respondent number 1 and print the name of Shri Vivek Shri NAIFA as that appearing for respondent number 1. None appears to the petitioner. Petitioner is however directed to furnish copies of the above petition along with annexures on the counsels who are appearing for the respondents. None were to appear for the petitioner on the next date of hearing. Again, challenge. ಕೆಲಸ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಇದರಲ್ಲಿ ರಿಲೀಫ್ ಇರೋದು ನಾಟ್ ಟು ಕ್ಯಾರಿ ಔಟ್ ಇನ್ ದರ್ ಪ್ರಾಪರ್ಟಿ ಅಷ್ಟೇ, ನೀವು ಕ್ಯಾರಿ ಔಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ. Unware to apply for the petition on the next date of hearing. The petition will add on past released on 19/7. E-auction. ಇವಾಗ E-auction ಆಯ್ತಾ?
The
Not
second
yet.
player will have the B, first player is not survive. Second player will have the issue established and directing the respondent authority to consider the representation dated 31.
We'll direct them to consider.
Remaining portion of it is the BDA. But it's not covering the entire area, they want it to action.
ಇವಾಗ ಅವ್ರು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಮುಗಿಸಿದ್ರೆ ನೀವು ಅದೆಲ್ಲ ಪ್ಲೇಸ್ ಮಾಡಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ವಾಟ್ ಎವರ್ ಯು ಅಪ್ಡೇಟ್. ಎಸ್ ಸರ್.
Last paragraph, site 17 ಮತ್ತು site number 15 specification ಮಾಪನ ಮಾಡಿ ಅದರ site information index rearrange ಮಾಡಬೇಕು.
They don't come in the way of the BDA. Within my site, that in order to BDA itself, they are marking.
Let them, ನೀವು ಕೇಳಿರೋದು ಫಾರ್ ದಮ್ ಟು ಮಾರ್ಕ್ ಇಟ್ ಮಾಡಿ. ದಟ್ಸ್ ವಾಟ್ ಯು ಆಸ್ಕ್ಡ್ ಫಾರ್ ಇನ್ ಪ್ರೇಯರ್ ಬಿ. ವಿಲ್ ಅಲೌ ಪ್ರೇಯರ್ ಬಿ. ಪ್ರೇಯರ್ ಎ ಡಸ್ ನಾಟ್ ಸರ್ವೈವ್. ಓವರ್. ಸೊ ಪ್ರೇಯರ್ ಬಿ ವಿ ಆರ್ ಅಲೌಡ್. We'll permit you to furnish further documents. Petitioner is before this court, seeking for the following relief. The petitioner claims the allotment of plot number 7, site number 17/A, situated the vendor of the petitioner was the allottee of site number 17/A, situated at 11th block, Junction 268, Bangalore, measuring east to west 6 meters and north to south 12 meters. In 2015 in the more sales agodi. ನೀವು ನೋಡ್ರಿ ಇಷ್ಟು ಬೇಗ ಇಷ್ಟು ಸೇಲ್ ಆದ್ರೆ ಏನೇನೋ ಇದೆ ಇಲ್ಲಿ. ಬಹಳ ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಮಿಸ್ಟರ್ ಕೃಷ್ಣ ಅವರು. ಓದಾಗಲೇ ಅದು you get to see that there is something wrong with it. ಅದು ಏನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾನು ಅರ್ಥ ಆಗುತ್ತೆ. ಬಟ್ ಎನಿವೇ ಇಲ್ಲ ಡೈರೆಕ್ಟ್ the petitioner also applied is voluntary surrender. The vendor of the petitioner had already also, the said plot had been allotted to the vendor of the petitioner under the BDA incentive scheme for voluntary surrender of land, packet rules 1989. The petitioner vendor had also applied for sale of additional land abutting site number 17/A. The sale came to be registered in favor of the vendor of the petitioner on 17/8/2015. While things stood thus, the Language Development Authority issued a e-auction notification on 9/3/2018 to e-auction site number 17/A. Hence, the petitioner objected to it and filed writ petition WP number 14229 of 2018, challenging the e-auction notification. Since the e-auction was not proceeded with, the said writ petition was disposed. Once again, another e-auction notification came to be issued on 22/9/2018. Again, the petitioner gave a representation indicating the petitioner's ownership about the above site. It is challenging the said notification that the petitioner is before this court. During the pendency of the above matter, the BDA has given up on the e-auction notification, and as said, the prayer A sought for by the petitioner above has been rendered infructuous. As regards prayer B, Shri K. Krishna, learned counsel for the respondent BDA, would fairly submit that respondent BDA would consider the representation of the petitioner given a period of 4 weeks from the date of receipt of a copy of this order. In view of the above, I pass the following order. This petition is allowed in part. The mandamus was issued directing the respondent to consider the representation dated 31/3/2018 by Annexure S and representation dated 24/9/2018 by Annexure V. The petitioner is also permitted to file such other and further documents that the petitioner wishes to rely upon in support of the said representation within a period of 2 weeks from today. The respondent BDA is directed to dispose of the said representation within a period of 4 weeks thereafter.
Represent the petitioner, madam.
Yes, Mr.
We are questioning, the petitioner is questioning the allotment of a site along with the consideration for the allotment. Because it is an alternate site.
You have entered appearance? Just one moment. Shri B.S. Sachin has entered appearance. Registry is direct. Delete the name of Shri C. Ramakrishna as that appearing for the respondent. Did he?
It's the alternate site, my lord.
Just one moment, please. ಹಾಕಿದಾರಲ್ಲ
Objections ಅನ್ನ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ನಮ್ಗೆ.
Objections ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ, ವಕಾಲತ್ನಾಮ ಅಷ್ಟೇ ಅದು.
ವಕಾಲತ್ನಾಮ ಹಾಕಿ ನಂತರ they have not filed objections.
ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ objections.
Not filed, my lord.
ನೋಡಿ ಸೀಲ್ ಏನ್ ಡೇಟ್ ಇದೆ ಅದು? ಯಾವ ಕೇಸಪ್ಪ? 5730 ಇವತ್ತು ಕರೆದಿರೋದು. ನೀವೆಲ್ಲ ಬಹಳ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ತೀವಿ. That counsel for the respondent seeks for and is granted 2 weeks time finally to file a statement of objection. Objection is going to be filed on before 21st, released on 26th. Either the objection act or 9/1 act. Yes, madam. Also. Committee go with. ಹೇಳ್ಬಿಡಿ ನಿಮ್ಮ ಸೀನಿಯರ್ ಕಮಿಟಿ ಕಳಿಸಿ. Petitioner is before this court seeking for the following relief. The appointment bench of this court and so on. Para 91I. 91I. Who is appearing for respond number 2? Sunita Singh. Where is respond number 2? She is no longer on the panel. She is no longer on the panel. Ms. Sunita Singh is no longer on the panel. We'll have to issue notice to somebody else. Ms. Sunita H. Singh is no longer on the panel of the BDA. Hence, Shri Suresh Patil is directed to accept notice for respond number 2. Counsel for the petitioner to furnish a copy of the petition along with annexures on the said counsel. What about you? You have filed your objections? You the objections to that. BDA the objection to that. Objections having already been filed. Released on 19/7/2022 for final hearing. Objections copy no ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಇಲ್ಲ ಆಮೇಲೆ ನಾನು ಏನು ಇಲ್ಲ ಅಂತಾರೆ.
However, for sites adjoining my property, site number 26 and 27 there, that value development charge at the rate of 159 rupees per square foot. For me, that's calculated at 1,556 per square foot. Normally for me, for other people, that's calculated the fixed rate. Site number that produce those savings and those.
So Article 14. Article 14. For illegal demand. For illegal demand, Bharat. You show us on what basis you made a higher demand on them compared to the other people. There are details as regards certain people.
Page number
11.
In the catalog, site number 19,
Yes.
And for 26 and 27, 28 and 29, 84 lakhs.
Per square foot rate ಎಷ್ಟಪ್ಪ? ಅವ್ರು ಕೇಳ್ತಾರೆ, ಅವರೇ ಮಾಡಿರೋದು ಕ್ಯಾಲ್ಕುಲೇಷನ್.
Yes, you are. Then what? Other.
And the 2 crore 28 was reduced to 16,21,000. Where is the table for that? Where is the table for that? So basically it was made into 159 rupees per square foot. So you'll have to collect from them also at 159. So anything over 159, if there is not something pending, they will give. If you have collected more, you have to give back. Ashtetane. So 159. Fairly submits. Order. Petitioner is before this court, seeking for the following reliefs. The petitioner is the owner of the property bearing site number 28 and 29, form in survey number 41/1B, 41/2A, 41/2B, 41/3 of Rachanalli village, Defense Enclave, second phase, Alkavati layout, Bangalore South, Karnataka. The respondent number 2 had issued a notification, white sailed dated 14/3/2001. Respondent number 2, BD, had issued a notification on 3/2/2003, indicating its intention to acquire the property, acquiring several properties, including that of the petitioner. A final notification came to be issued on 23/2/2004. Since the lands in the aforesaid survey numbers were developed, the second respondent had resolved to allot the sites to the owners of this, to the sites to the site owners on payment of development charges. In pursuance thereof, various allotment letters were issued and a demand was made. The said demand was challenged by several persons in several writ petitions, namely WP number 49255 of 2014, etc. In the said writ petition, the said writ petition came to be disposed, directing the BDA to consider the representation given by the said plot owners. In pursuance thereof, the BDA revised the allotment charges to rupees 159 per square feet. The petitioner contends that the petitioner is also entitled to similar relief, and as such, the demand made by the respondent on the petitioner being in excess of rupees 159 per square foot, the said demand is bad in law and has to be scaled down to rupees 159 per square foot. It is in that background that the petitioner is sought for the aforesaid reliefs. The petitioner further submits that the petitioner, under threat of payment of further interest and or non-allotment of the site, was constrained to make payment of a sum of rupees 10,500, when in fact the due amount was rupees 8 or 9 lakhs for it. Sum of rupees, excess, what is your calculation? What is your cycle area? Is blank. That is 5,400 into 159 bracket close. That's an excess amount of rupees 75,48,900 has been collected by the respondents, which is required to be refunded. Correct. Considering that this court had passed orders in WP number 4, there are two, Allah. 49255 of 2014 and WP number 15966 and 16684 of 2017. And the considered opinion that the benefit of the said orders and the benefit of the revision affected by BDA is required to be extended to the petitioner also. Hence, the respondent is directed to refund the amount in excess collected by the respondent and retain only an amount of rupees 159 per square foot as refixed by the BDA itself. Petition stands disposed. The amount shall be refunded within a period of 6 weeks. ನಿಮ್ಮ ಹಿಂದೆ ಇರೋರು ಒಂದು ವಾರದಲ್ಲಿ ತಂದು ಕೊಟ್ಟರು ಹಂಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಬರೋದಿಲ್ಲ ಆದ್ರೆ ಬರಲ್ಲ 8 weeks from the date of receipt of a copy of this order. Counsel for the petitioner is permitted to furnish a copy of the order to the respondent. No interest. You should have come earlier. You have come in 2019. What?
First order was starting 2015. Immediately 2016, I approached the petition. It is nothing. So 2017, I approached the High Court with the petition asking for the minor, which came to me around 2019. Subsequent to that, I will not comply with the order of the court and file a contempt petition.
Where have you stated that? Sorry?
I think 2016.
Where have you stated about the contempt petition? Page number? You are not stated in already 6% interest has been ordered.
That was I think the since 2016 in fact, the representations that I sought for were of second of 2016 and 2016.
The petitioner was therefore constrained to approach this court in WP number 15966 of 2017, wherein this court, by its order dated 9/1/2019, had directed the second respondent to refund the excess amount within a period of 3 months, along with interest at the rate of 6% per annum. Despite this said order, the payments were not made, and the petitioner filed contempt proceeding in CC number 481 of 2019, where the respondent apologized for, submitted his unconditional apology, but however, had issued an endorsement dated 1/7/2019 that the wherein it was stated that there are no amounts which are due and payable to the petitioner, on the ground that the same would cause financial loss to the respondent number 2, since there are several sites which have been allotted and the development charges are reduced, the same would have a cascading effect on all the sites. It is agreed by the same that they said, you not worded it properly there. It is agreed by the same that the petitioner is before this court challenging said endorsement.
The order that was passed was a manifest. The previous order of this Honorable Court was to consider the representation. If I'm entitled, due to the amount of 6%, all past orders on the application. It was more to consider the representation.
Now we will pass orders of 18% and 21%. After what is sauce for the goose is sauce for the gander. The Article 14 violation ಆಗಂಗಿಲ್ಲ. ನೀವು ಹೆಂಗ್ ಮಾಡ್ತೀರಿ? Is this even conscionable? ಸರ್ ಒಬ್ಬರಿಗೆ 159 ಇನ್ನೊಬ್ಬರಿಗೆ 1000 rupees ಮಾಡಿದ್ರೆ ಏನಿದೆ? You cannot revise that. Have you collected from all of them at the 1000 rupees? You can't do this. The petitioner, first of all, the reasons given by the respondent number 2 that it will cause financial loss cannot be accepted by this court. The respondent number 2 is a statutory authority created under a statute which is required to discharge its public functions in the interest of the citizens of the country and more particularly the citizens of Bangalore. The respondent number 2 is not in a commercial business so as to make commercial profit and or to contend that there will be loss to the financial loss caused to the respondent number 2. That cannot be a ground. That also cannot be a ground for respondent number 2 to violate the principles of Article 14 of the Constitution of India and charge differential rates for the development charges for different persons. Once the development charges are being charged at 159 rupees per square foot for similarly situated site owners in Defense Enclave 2, Arkavati layout. All the persons in Defense Enclave 2, phase 2 would be entitled for the same benefit. And the petitioner would also be entitled to make payment of only 159 rupees per square foot as development charges. The difference. We are the above difference also. Since this court had already directed payment of interest at the rate of 6% in its order dated 9/1/2019, WP number 15966 of 2017, and the respondent has issued an endorsement contrary to the directions and contrary to Article 14 of the Constitution, I deem it fit that the respondent be liable to make payment of interest in terms of the BDA allotment of site rules. Rule number 13. Rule 13(1). Sub-rule 1 of Rule 13 of the BDA allotment of site rules 1984. That is calculated at the rate of 18% per annum for the first 30 days when the amount fell due, and thereafter calculated at the rate of 21% per annum till the date of payment. The payment will be made within a period of 8 weeks from date of receipt of property. ಮತ್ತೆ ಬನ್ನಿ ಸಚಿನ್. ನಿಮ್ದೆ ಎಲ್ಲ ತಗೊಂಡು ಇಲ್ಲೇ ಇಟ್ಕೊಂಡು ಏನು ರೆಡಿ ಹೇಳಿ. Marginal land. There are no other claimants. No applicants. The petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of site bearing 37/4, card out of survey number 161, situated at Vadarapalya, Rajajinagar, first floor. Now BBMP assigned the BBMP Khata number 4-70-4, measuring east to west 35 feet and north to south 25 feet. I purchased the same in the year 1996. Subsequent to the purchase of the same, the petitioner became aware of there being a marginal site situated on the which side? On the western side of the house of the petitioner. Sketch ಇದೆ page 30. ಇದೇನ್ ನಿಮ್ಮ ಪ್ರಕಾರ ಏನು what is the measurement of this side? 37/4 is 35/25. ಅದರಲ್ಲಿ 18/35 marginal land ಅಂತ. One third ಬರುತ್ತೆ. Less than 1/3. ನಿಮ್ಮ ಸ್ಕೆಚ್ನು ಕರೆಕ್ಟ್ ಇಲ್ಲ, ಅವ್ರು ಹೇಳೋದೇ ಕರೆಕ್ಟ್. ಯಾವ್ದಾದ್ರು ಒಂದ್ ಕಡೆ ಆದ್ರೂ ಸೇಮ್ ಮ್ಯಾಚ್ ಆಗ್ಬೇಕು 35ಗೆ. It has to be less than 1/3. It can't be virtually the same measurement. 750 square feet means the property. 630 square feet marginal land. Cannot happen. Marginal land measuring 18/35 feet, totally measuring 630 square feet. And as such, the petitioner made an application for allotment of the marginal land. Since the same was not done, the petitioner is before this court seeking for the opposite relief. The petitioner admittedly owns 835 square feet of plot area. The petitioner is now contending that the property beside this plot, measuring 630 square feet, is a marginal land. I am of the considered view that such a contention cannot be raised by the petitioner. More so, when the marginal land now claimed is in excess of 1/3 of the sited area of the petitioner. By way of the present petition, the petitioner cannot seek for allotment of one more plot or land in excess of 1/3 of the area held by the petitioner. As said, there being no grounds made out, the petition stands dismissed. ಯಾವತ್ತಿದೆ ಅದು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರು. ನಂಬರ್ ಏನು ಎಲ್ಲ ಬರುತ್ತೆ ನೋಡಿ. ಲಿಸ್ಟ್ ಕೊಡಿ ಅಂದ್ರೆ ನೀವು ಕೊಡಲ್ಲ. ಅದು ಕಮಿಟಿ ನೋಡ್ಕೊಳತ್ತೆ. We can't entrench upon the committees. That you can raise before the committee. If you are before the committee in another matter, we cannot take that jurisdiction. We cannot get into that at all, because that is for the committee to consider. Now we are only considered that they're selling the civic corner site and stray sites by auction without allotting it to the persons who are already there and sending you out to Kempegowda layout or another layout. date of application को date of birth को ಏನ್ ಸಂಬಂಧ ರೀ? What is the rational classification for that? So whoever is older will get in spite of 7 attempts, 8 attempts. Produce that also. Make the above matter. List to produce ಮಾಡಿದ್ದೀರಾ? Both the council submit that the above matter is connected to WP number. Blank which is listed on 12/7. Connect the registry that connect and relist on 12/7. Mr. Bhatt.
Connection is blocks. If you have a block with data for your license, then you have NDC connection given to
License for?
License for the shop. Commercial shop, which is license kind of this one. Then you have the license letter. At connection A1 is number 26, that is not 11 August 2006.
Yes.
As per this letter, 5 years, time has been granted. The lease period is 5 years. 5 years.
Page number, clause.
29, clause 11. License of
Yes.
Then this license is valid up to 2011.
Yes.
And in the meanwhile, value that the state authority has undertaken to demolish that building and construct new building. And therefore, that they have not renewed the license.
When was it demolished?
They have not demolished, but they said that they are going to.
So you are continuing in occupation even now.
Yes,
You are continuing in occupation even in 2022.
yes.
11 years, sir.
No.
Yard extension ಆಗೋಯ್ತು.
Then connection B kind of the impact number 36 is last balance there. Total amount paid 50,72,042.
Yes.
Rent amount is 43,650,43. Service tax 7,69,900.
ಯಾವ ವರ್ಷದಿಂದ 2006 ಇಂದ 19 ವರೆಗೂ ನೀವೇನೋ ಹೇಳಿದ್ರೆ ಒಂದ್ ತಿಂಗಳಿಗೆ ಕೊಟ್ಟಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
As per this statement, 43,65,043 was rent, and I have paid 50,72,042. Then they have issued a notice book page number 37, demanding an amount of 17,825. 982 ಪರವಾನಗಿ ಶುಲ್ಕ ಬಾಕಿ 17,83,827 ಬೆಳಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಕೈಗೊಂಡಿಲ್ಲ. Then I have challenged this because this since that I have made excess amount as of 2000, I have challenged and this 17,827 why they are demanded to what else that they are giving since I am paying regularly. Then this on to quote the past order and
yes,
and directly the respondent to vehicles. And give reasons for what is the reason where they have demanded me. Then I have given detailed objection in page number 43. And we have produced and we have explained date wise in your last period in page number 42, para 6. Para 6 accordingly, objector has confused the license fee from 31 criminals. And amount ಯಾವ ಪ್ರತಿ ವರ್ಷ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟು ಹೋಗಿದ್ದೀನಿ ಅಂತ 2019 budget.
What is the enhancement in our idea?
Enhancement is not the 5 immediately after 5 years, not 5% enhancement advertised. But license has not been released.
Then why don't you vacate the premises?
We have since we not they have not used demolition act now, but regular purpose of that point of time. Accordingly, what we are doing, we are accepting.
Have you paid the enhanced rentals?
That after 2012, that enhanced rate will not that, but excess amount that we have paid, but particularly enhanced amount has not been paid.
Now you pay interest also. Can't have this.
Then the NDC lecture, yeah, I have given representation saying that they have paid. Yes, why is it never and some of the staff did not then they have not said that I have to pay as against 70 lakhs. They have said by issuing another notice that is 6/1/2020. It's a mind thinking about then about the then we have started by issuing a letter another year. But no action now activity and the state then by virtue of direction issued by the Honorable Court in India, they have not this Honorable Court after hearing and considering the objections filed by the petitioner, they are passed. Ultimately, they have passed order without providing BDA ದಿನಾಂಕ 4/2019 ನೀವು ದಿನಾಂಕ 22/2022 ಪ್ರಾಧಿಕಾರ ಕಾನೂನು ಅಧಿಕಾರಿ 2 ಮುಖ್ಯ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಕಾರ್ಯದರ್ಶಿ 4 ವಿಚಾರಣೆಯನ್ನು ಕೊಡಲಾಗಿದೆ. ಮಾನವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ತೀರ್ಪು ತಾವು 21 ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಸದರಿ ವಿಚಾರಣೆ ನಡವಳಿಕೆ ಈಗಾಗಲೇ ನೀಡಲಾಗಿದೆ. ಸದರಿನ ಆರ್ಥಿಕ ವಿಭಾಗದ ಲೆಕ್ಕಕಾರರು ದಿನಾಂಕ 30/2023 ರವಾನಿಗೆ ಶುಲ್ಕ ಬಾಕಿ 22,26,000 ಹಾಗೂ ಬಡ್ಡಿ ನಾನು ಕೇಳಿದ್ದು 18,95,730 ಸೇರಿ ಒಟ್ಟು 41,22,626 ಯಾವಾಗ 17 ಲಕ್ಷ ನಾನು ಜಾರಿ ಮಾಡಿ ಈ ಪಾವತಿ ನಡೆಸಿದಾಗ ಎಷ್ಟೋ ಒಂದು ಬಾಕಿ ಪರವಾಗಿ ಶುಲ್ಕ ಬಗ್ಗೆ ಪಾವತಿ ಉಪಕಾರದ ಸೇವೆಗೆ ಪತ್ರ ನೀಡುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ. ತಾವು 2 ದಿನಗಳ ಕಾಲ ಇದುವರೆಗೆ ಉಪಕಾರದ ಸೇವೆ ಬಳಿಗೆ ಸಂಖ್ಯೆ 45 ಲೈಸೆನ್ಸ್ ದಿನಾಂಕ ತಾವು ಪರವಾಗಿ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ಪರವಾನಗಿ ಶುಲ್ಕ ಬಗ್ಗೆ ಅದರ ದಿನಾಂಕ ರಾಜ್ಯ ಸಮಿತಿ 17,83,800 ಆದರೆ ಪರವಾನಗಿ ಶುಲ್ಕ 17,83,000 ಬಾಕಿ ಪರವಾನಗಿ ಪಾವತಿಸಿ ನೋಟಿಸ್ ಸಲ್ಲಿಸಿದ ವಿಚಾರಣೆ ಪಾವತಿಸಲಾಗಿರುವುದಿಲ್ಲ. ಈ ಮೊತ್ತದಲ್ಲಿ ಸೇರಿದ ಬಾಕಿ ಪರವಾನಗಿ ಬಡ್ಡಿ ಚಕ್ರಪಟ್ಟಿ ದಿನಾಂಕ 15/2020 ಪ್ರತಿಯನ್ನು ಈಗಾಗಲೇ ನೀಡಲಾಗಿದೆ. ಬಾಕಿ ಪರವಾನಗಿ ಬಡ್ಡಿ ಮೊತ್ತವನ್ನು ಸಹ ರೂಪಿಸಲಾಗಿದೆ. ದಿನಾಂಕ 22/2020 ಸಂಬಂಧಿಸಿದಂತೆ ಮಳಿಗೆ ಸಂಖ್ಯೆ 23,95,184 ಹಾಗೂ 19,42,65,000 ಬಾಕಿ ಸದರಿ ಮತ್ತು statement connection B which they have statement as per their statement in which they have passed order, they have filed statement connection to this court.
Yes.
You will also get number 26 of their statement which they have filed connection order.
Yes.
Total license fee from another employees are total interpretation. 67,66,760 pending which note this. Since the notice which I have read appears 70 lakhs, then 42 lakhs, and payment, whatever amount which I have paid also there. The total service tax 36,007, 5,62,314, and GST from 17,351,570. And interest at 17,24,090. Total amount 94,472. Total license fee 56,65,000. Balance as of 37,38,689. This is not the figure which they have given my respective submission is as of that date, which we have charged 17 lakh they have not. And they have clearly admitted that 56 lakhs that we have paid and additional 3 lakhs deposits are with them. And the interest which they have claimed 70 lakh 24,000 on which there is no clarification has been brought. And apart from that, I have not up to issuing this 2017, whatever amount which is required continuously from the I have deposited, they have accepted. Till 2019, when they have raised 17 lakhs, there is no other notice, and they have not brought into the notice that since they have not paid, I have not paid that 5% enhancement. Apart from that, the interest which they have paid on amount which I have paid. And we are not running the business since that they have said building the amount almost everyone.
Did you hand over the possession, Mr. Bhatt?
I have requested them to
where is the letter for that?
No, I have that letter I have requested. No, I'm not. I'll produce.
Please don't take.
No,
don't do these kind of.
Please do.
When BDMLA, we can blame them for a lot of things. But if you don't pay the rentals also, you don't pay the GST also, why should they build anything for you? And you say that because it is not renewed, I won't pay the enhancement.
No, I have paid the amount which is as of 2026 and interest which they have calculated and GST.
We are not satisfied, Mr. Bhatt. We will dismiss this. We are not satisfied with it.
No, insofar as when we see the amount which they have demanded and the no opportunity has been.
If you have any dispute, go for a civil suit. We can't decide all this.
But insofar as I respect the submission before this report, they have one statement and notice. Let them come before this report.
Not this court. This court is not going to lead evidence, Mr. Bhatt.
Can you see for a moment, see the earlier notice, 17 lakhs. And no interest claim from the paid amount.
Yes.
That statement is clear.
Yes. Petitioner is before this court.
And interest, since I am not doing individual, I can't pay.
We can't look into those issues, Mr. But in this proceeding, these are writ proceedings.
But
we can't look into those.
Injustice, apparently, that's injustice.
You have a remedy in a civil court.
I have got remedy. Insofar as excess amount which directed, no opportunity has been granted. And not let them justify what.
We have
They
heard
have
you, Mr. Bhatt. You're repeating the same thing.
No, not insofar as not claim.
Allow us to pass orders now.
Logically, I'm not.
Petitioner is before
But
this.
the amount which they have demanded, kindly consider that the interest on paid amount. If they are coming, yes, this is 5%.
Then you should come clean saying, I'll pay the 5% enhancement. You don't come clean.
Please, my lord.
5% enhancement ಕೊಡ್ತೀರಾ?
5%.
ಅದು ಕೊಡಲ್ಲ ಅಂತೀರಾ?
No. I'm since interest 17 lakh.
Mr. Bhatt, you have extended your stay beyond the 5 years. After 5 years, you are supposed to pay 5% enhancement. You have not paid 5% enhancement. 10% enhancement. 10% enhancement and interest on that, you have to pay.
Let them give statement.
You calculated, ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
I have calculated whatever I have paid.
ನೀವು 10% calculate ಮಾಡಿಲ್ಲ, that's a modified reply.
No, I have stated.
ಎಲ್ಲಿ 10% ಎಲ್ಲಿ calculate ಮಾಡಿದ್ದೀರಾ Mr. Bhatt? Mr. Bhatt, now you are on abuse of the court. ಇದುವರೆಗೂ modified ಆಗಿತ್ತು, ಇವಾಗ abuse ಗೆ ಬರ್ತಾ ಇದ್ದೀರಾ. So, ಎಲ್ಲಿ 10% ಎಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ ತೋರಿಸ್ಬಿಡಿ ನಿಮ್ಮ ರಿಪ್ಲೈ ಆಫ್ 2111. 10% ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದೀರಾ?
10% ನಾನು ಹೇಗೆ ಹೇಳಿದ್ದೀನಿ ಅಂತ not really. Now 10% they have not paid. Therefore, that I have not paid from 2012 to 2019.
ಅಷ್ಟೇ, ಅದಕ್ಕೆ ಕೊಡ್ಬೇಕು. ಆಗತ್ತೆ, you continue in possession, but you don't want to pay enhancement. That's modified.
No, insofar as that 70 lakh imposition without interest to service.
Petitioner is before this court seeking for the following.
My respectful submission is not that I can't pay that big amount which they have demanded.
That is for them to recover the way that.
17 lakhs which they have paid. Since I have approached.
Can you please allow us to dictate now?
Please.
The petitioner had applied for grant of license in respect of premises number 42FF, measuring 89.96 square meters, that is 969 square foot in Vasur Sarjapur Road, HSR BDA complex. The lease was granted to the petitioner on 11/8/2006, an initial period of 5 years. In terms of the lease, the amount of rupees 29,000 rupees per month was required to be paid as license fee for the first 5 years, and on renewal thereof, enhancement of 10% on the last paid rental was to be made. There being certain disputes as regards the every 2 years. There being a dispute as regards only the 2 years. Where is the clause? 18%. 2 ವರ್ಷದ ಶೇಕಡ 10%. 29,000 rupees per month, and the rental was to be increased by 10% every 2 years, as stated in clause 1 thereof. There being certain dispute as regard to payment of rentals, the respondent issued notices calling upon the petitioner to make payment of the due rentals and interest. Challenging the same, the petitioner had approached this court in WB number 50268 of 2019, wherein this court I directed I read down the said demand notice as a show cause notice and directed the respondent to consider the representation stroke replies to objections of the petitioner in accordance with law and pass necessary orders. In pursuance thereof, a reply was submitted on 21/11/2019, and thereafter an order was passed on 10/2/2020, which is under challenge in the present proceedings. Shri Ganapati Bhatt, when counsel for the petitioner, would submit that the petitioner has made payment of all dues.
And up to 2020, I have paid enhanced rent also. Thereafterwards, it is not renewed. I have
All
paid
dues,
all day.
including enhanced del ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಸೇಮ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ
Yes, you know, up to 2011 enhanced rate code.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ 3,48,000 from every year please.
Let me see. According to this, complete 1 year 2011 to 12 months.
Please read para 5 and 6 of your own reply. 3,48,000 from 2007 to 2008, 7, 8 to 9, 10 to 11, ಮತ್ತೆ 11 to 12, ಎಲ್ಲ same 3,48,000.
ಅಲ್ಲಿ principal has given monthly rate amount of 29 and that comes to 3,40,000. Rent from 11 to 21 days.
Do you want to persist with that submission, Mr. But you want to say that every 2 years you have enhanced till 2011?
Yes.
You want to say that? Shri Ganapati Bhatt, when counsel for the petitioner submit that the petitioner has made payment of the due rentals, there is no amount due by the petitioners.
As of 2011 and thereafterwards one of the
ಇವತ್ತು ಡ್ಯೂ ಇದೆಯಾ ಇಲ್ಲೋ? As on today ಡ್ಯೂ ಇದೆಯೋ ಇಲ್ವೋ?
that in case enhanced rate will be there.
In case ಅಲ್ಲ, conditional submission ಮಾಡಬೇಡಿ, direct submission ಮಾಡಿ. What is your submission? Is there a due amount or no?
Only enhanced amount to be paid.
So will you pay that?
This one.
Will you pay that? How the other thing?
Since not 10% not increase somebody for direct 10%.
We are not. Don't. This is what we say is malified.
10% I will pay.
We'll deal with it. Every amount has been paid. However, you submit that if this court were to come to a conclusion that the 10% enhancement has to be paid, the petitioner is willing to make payment of the same.
My submission is this.
His contention is that since the lease deed was not renewed post 2011, there is no requirement for the petitioner to make payment of the enhanced rentals
As per the license.
as per the lease deed. Apart therefrom, he submits that from 2006 to 2011, the petitioner has made payment of the enhancement of 10% every 2 years. Shri K. Krishna, in that background, he submits that the above reliefs are to be granted. Shri K. Krishna, learned counsel for the respondent of above submit that the petitioner has taken advantage of the respondent and not paid the amounts due and has continued occupation of the premises even post the expiry of the term of the lease. And when a demand was made for payment of the due amounts, the petitioner has indulged himself in unnecessary litigation. He therefore submits that the petition is liable to be dismissed. Third, so and so. It is not in dispute that the monthly rental fixed was rupees 29,000 per month. It is also not in dispute that the rentals were to be enhanced by 10% every 2 years. And if there is any due amount, then the dues would bear an interest of 18% as per the lease deed. The contention of Sri Ganapati Bhatt, firstly, is that from 2006 to 2011, the enhanced rentals have been paid. The statement and reply, which has been produced at Annexure E to the writ petition, indicates that from 2006 till 2011, the rentals which have been paid is at the rate of rupees 3,48,000 per annum. Taking into consideration the rental to be rupees, if the same is divided by 12 months, it comes to rupees 29,000 per month. Thus, it is clear that the submission made, it's clear that a false submission has been made, that the petitioner has made payment of enhanced rentals from 2006 to 2011. Inasmuch as if enhanced rentals had been paid, the rentals would have to stand enhanced in 2008 by 10%, in 2010 by another 10%, which has not been done. What has been paid by the petitioner is only rupees 29,000 per month from 2006 till 2019. The second contention addressed by Sri Ganapati Bhatt as regards non-payment of the enhancement is that in view of the non-renewal of the lease, they said the enhanced rental has not been paid. It is not in dispute that the petitioner continues to be in occupation of the premises. When the petitioner can take advantage of the fact of non-renewal by staying in the premises, the petitioner, when the petitioner has continued to stay in the premises, the petitioner cannot take advantage of non-renewal. The basic requirement of the petitioner would have been to make payment of the enhanced rentals every 2 years. Correct. The petitioner cannot, the conduct of the petitioner leaves much to be desired. The petitioner is seeking to take advantage, undue advantage of the non-renewal of the lease deal for non-payment of the enhanced rentals, but has continued to be in occupation. If at all there was bona fides on part of the petitioner ought to have vacated the premises and handed over the said premises to the BDA on the expiry of the term of the lease. That not having been done, I am of the opinion that the petitioner was required to make payment of the enhanced rentals. The petitioner not having made payment of the enhanced rentals, the interest also would be liable to be paid by the petitioner at the rate of 18% per annum on the defaulted amount. Correct. In view of the above, I am of the considered opinion that both the contention addressed by Sri Ganapati Bhatt are not sustainable and are therefore rejected. Though the contention of the petitioners border on mala fide and amount to abuse of the process of the court, this court refrains from making any comments or passing any directions in relation thereto. Since there are no grounds made out in the above petition, the petition stands dismissed. Admittedly, the petitioner is also Mr. Bhatt. Admittedly, the petitioner has also not paid. In the year 2017, the Government of India introduced the payment of goods and service taxes. And prior to that, there was service tax which was applicable to, in the year 2017, service tax was made applicable to commercial leases. Subsequent thereto, the Government of India imposed goods and service taxes on rentals to be paid. Admittedly, these amounts have also not been paid by the petitioner, which are statutorily liable to be paid by the petitioner, collected by the BDA and remitted to the concerned account. These not having been done.
Prior to 2017,
Whenever it is due, Mr. Bhatt, now if you persist, we have to hold it as abuse of the court. Please don't do this.
I leave it to this court. Since that they have apparently I have this document 70 lakhs they have paid. Since I have approached this honorable court, they have made it to 42 lakhs.
We are concerned about, he is concerned about your malafide. I mean, So when will you get it, Mr. When will you get it? 57 at the request of the council for. Then please wait when it reaches will. Not that long, not that long. 12 57 at the request of council for respond number 2, released on 12/7. Please come back later, madam. Not now.
ಸರ್ 2:30 ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ? ಇದೇ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ? ವಾಟ್ ಆಫ್ ಸರ್?
Original file.
ಅದೆಲ್ಲ ಲೇಟ್. ಯಾವ್ದನ್ನ ತಗೊಂಡೋಗ್ರಿ ಇಂಟು ಬಿಟ್ಟಿದ್ದಾನೆ ಕನೆಕ್ಷನ್ಗೆ ನಾನು ಪೂರ ವಿಡಿಯೋ ನೋಡೇ ಮಲಗಿದ್ದು ನಿನ್ನೆ ಪೋಸ್ಟ್ ಲಂಚ್ ನೋಡಿದೆ ನೀವು ಏಜಿ ಎಲ್ಲಿಗೆ ಹೋದ್ರಿ ಯಾರ ಮಾತ್ರ ಏನ್ ಮಾತಾಡಿದ್ರಿ ಹಂಗೆ ಹೋಗ್ಬಿಟ್ರು. ಹೌದು ಅದು ಹಿಂಗ್ ಕಾಣಿಸ್ತು ಹೋಗ್ಬಿಡ್ತದ ಯಾವ್ದು ಮುಂಚಿನ ಇದ್ರಲ್ಲಿ ನಿನ್ನೆ ಎಫೆಕ್ಟಿಗೆ ಎಲ್ಲ ಜಡಿಸಕ್ಕೆ ಹಂಗೆ ಇಲ್ಲ ಆಗ್ಬೇಕು ಇಲ್ಲ ಅಂದ್ರೆ ಇವ್ರದೆಲ್ಲ ಬಾಳ ಹೌದಾ ಮಾಡಿ
experience of the
జిల్లాలో ಎಷ್ಟು ಟೈಮ್ ಮಾಡ್ತಾ ಮೆಸೇಜ್ ಮಾಡಿದ್ದೀನಿ ಆಗ್ತಲ್ಲ ತಿಂತೀಯ
ಹಾಯ್ ಮಮ್ಮಿ ಎಲ್ಲಿದ್ಯಮ್ಮ ಎಲ್ಲಿ ಇಲ್ಲ ಇಲ್ಲ ಅದಕ್ಕೆ ಶೋಭಾ ಟೆಕ್ಸ್ಟ್ ಮಾಡಿದ್ದೆ ಕರೆಕ್ಟ್ ಯಾ ನೀನು ಆರಾಮಾಗಿರು ಒಳ್ಳೆ ಡ್ಯಾಡಿ ಎಲ್ಲ ಇರ್ತಿಲ್ಲ ನೋಡ್ಕೊತೀನಿ ಅಲ್ಲ ಸುಮ್ಮನೆ ಆಯ್ನಾ ಅದಕ್ಕೆ ಓಕೆ ಹೇಳ್ತೀನಿ ಎಂದು ಪಾಪ
Again steps from where? 62. Counsel for the petitioner submitted the sole petition has expired. Seeks for and is granted 2 weeks time to file necessary application in the legal on it. We list on 27/7. Serial number 91. Huh? At the request of the counsel for the petitioner, we list on 27.
Serial number 81, my lord.
Interim order earlier granted is extended to next week.
Lord.
We list on 15/7.
Lord, serial number 90. Understanding was final disposal. 90.
Which other
Understanding was a final disposal. Small question is involved there.
Yes, we'll take it up.
The mail.
Serial number 81, my lord. Serial number 81. I need
Really?
2 weeks time to file objections, my lord.
Have you informed the petitioner, Mr. Girish?
Yes, my lord. Yes,
I
my
appear
lord.
for the petition, my lord. So date may be fixed, my lord, because 2 weeks was already.
N.R. Girish, the counsel for the respondent seeks for and is granted 2 weeks time finally to file a statement of objection by 21/7. We left on 27/7.
Much obliged, my lord.
Obliged.
And counsel for the petitioner submit that the above matter is connected with so and so registries that connect the said matters and we left on 20th of July. Petition has expired. 76. Then counsel for the petitioner submit that the sole petition has expired. She seeks for and is granted 2 weeks time to file necessary application. We list on 27/7. Shetty, the plan which has been now produced again shows a commercial area, future development. Last time it was clearly understood that nothing will be shown on that side, only the plan as regards the subject matter. Why again this has happened? No, but if you are going on giving these kind of plans,
What is the find out whatever has to be changed as per the plan, then finalize the plan, then submit.
Yes.
Whether tomorrow or after, that's what I.
Why should we?
Along with them, this is the officer, what issue we put, where they have objection, what correction has to be done. After doing, instead of getting a rejection, get it according to what are the rectifications they want. We do it and then submit it.
What is the other objection that you have?
Constructed area के मात्रा बांटे.
Huh?
They are shown unconstructed area also. We did it.
Really unconstructed area only there.
Just point out. I have raised the enforcement of metro.
Like plan.
How are you? Good.
Open land, yes, we understood. What is the other area?
Future development of opposite side of the pipeline road. Pipeline road.
Water supply pipeline road.
Pipeline road ಅಲ್ಲಿ
ಅಲ್ಲ ಇವಾಗ once this whole area gets removed, then that pipeline road becomes inconsequential.
ಈ ರೋಡಿಗೆ 24 ಅಡಿ ಬಿಡ್ಬೇಕು.
24 ಅಡಿ ಬರೋದು ಯಾವಾಗ when they develop this land, not now. ಅದು ಡೆವಲಪ್ ಆಗಿಲ್ಲ. Iವಾಗ we are concerned with this blue portion and this red portion, whether that is in accordance with law or not.
Then my lord, said ಇಲ್ಲಿ left side ಅಲ್ಲಿ overall.
You are appearing, Mr. Yes, please.
This area in the area which is very restricted of Bangalore,
What is built there now?
one is the city community, one is public park. The other area that's alongside also, which is not market, but it is the border on the left hand side top, is also the area which is very much the Bangalore development.
No, what we want is that this, whatever the area which has to be removed.
Now, what is sort of the done is this area, which is shown in the front. It is open for land future development from residential building along with the business sharing constructions. This connect to the connect with future development at all. Taking into consideration this open area, profile of
Oh, okay.
Yes,
Okay, no problem. No, ಅಂತೆಲ್ಲ ಬೇಡ. ಇವಾಗ ಎಷ್ಟು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಹೇಳಿ, ವಾಟ್ ಇಸ್ ಎಫ್ಐಆರ್ ಹೇಳಿ, ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಅಷ್ಟೇ. ಏನಿದೆ ಯಾವುದು ರೋಡ್ ಯಾವುದು? What is the width of the road?
Future development, commercial and roads.
Let us address. We will address each one. First contention of yours is that this red portion is built in a civic community and park area, which has been relinquished to BDA.
Also told that what has happened here, it's the area with the apartments are full. This area is included as a portion of land which will go to the benefit of the apartment structure.
This area.
This area itself.
No, we will come to that. No, your first contention is that this red portion is in civic community and park area.
Yes.
So relinquishment.
Also that is not for the between the two branches, the branches kind because there is a unmarked portion which is next to the big red block. There is one white block. That
Yes.
is also they have introduced some multi-level
Space for MLCP.
multi-level car park, which is also relinquished in our.
Okay, that is your first contention.
That's the first contention.
Yes.
Now, therefore, the setback area also, this setback area which is on the top left hand side column. Also,
Yeah, top left hand side corner andre red area na blue area.
Small red line area. This is called the O block.
Yes, block O. ಇದು ಕಾಣಿಸ್ತಾ ಇದೆ ಬ್ಲಾಕ್ ಓ ಅಂತಿದೆ. ಹೌದು. Yes.
They have to leave 7.5 meters of the home line or 13 meters. That is not left.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ?
7.5 ಕೊಟ್ಟಿದ್ದಾರೆ.
13 meters, no 7.
Now we sure. We have mentioned that.
Okay, that is point number 2. Amele?
The car parking lots, the lots, kind about the endorsement.
MLCP. Yes.
Stage 1 plus image will still marry that.
Yes, please.
ತಾವು ಸದಸ್ಯರು ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ಉತ್ತರ ಭಾಗದ ಜನತೆಗೆ ಹೊಂದಿಕೊಂಡಂತೆ ಪೈಪ್ಲೈನ್ ರಚನೆಯನ್ನು ನಮೂದಿಸಲಾಗಿದೆ. ಆದರೆ ಪ್ರತಿ ರಸ್ತೆಯನ್ನು RFP 2018ರಲ್ಲಿ 24 ಮೀಟರ್ಗೆ ವಿಸ್ತರಿಸಲು ಪ್ರಸ್ತಾಪಿಸಲಾಗುತ್ತದೆ. ಹಾಗಿರುವ ರಸ್ತೆಯು ಅಗಲವನ್ನು ನಮೂದಿಸಿ 24 ಮೀಟರ್ ವಿಸ್ತರಿಸಲು ಬೇಕಾಗುವ ಅಗತ್ಯ ಜಾಗವನ್ನು ನಕ್ಷೆಯಲ್ಲಿ ನಿಖರವಾಗಿ ಗುರುತಿಸಿ ಅಳತೆ ಮತ್ತು ವಿಸ್ತೀರ್ಣದೊಂದಿಗೆ ನಮೂದಿಸಿದೆ. ಸಲ್ಲಿಸಿರುವ ನಕ್ಷೆಯ ಕೋಷ್ಟಕಗಳಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 1,01,114 ಚದರ ಮೀಟರ್ ಎಂದು ಮಾತ್ರ ನಮೂದಿಸಿದರು. ನಮೂದಿಸಿರುವ ವಿಸ್ತೀರ್ಣ ಸರಿಯಾಗಿದ್ದರೆ ಅಥವಾ ಇಲ್ಲದೆ ಕುರಿತಂತೆ ಕಾರ್ಯ ಮಾಡಲು ಸಾಧ್ಯವಾಗುತ್ತಿಲ್ಲ. Number 1, objection number 1.
Insofar as your
That is this area. It is on the front side of the road.
we will come back to it.
So that it will be clear.
We are still not asked him a question. Why are you something? This 24-meter, which is a proposed road,
Yes. It is in the master plan.
it is in the master plan. So you have to acquire it at some point of time.
The master plan. If I don't acquire 5 years or more, then the road so far the road is not
It won't lapse.
under the BD Act. It remains the same.
It remains.
It remains.
But at any point of time that you want to use it,
If I want to increase the width of the road, we have to utilize it. Therefore,
you have to acquire and then utilize.
relinquishment. This side road is relinquished.
Yeah, 24-meter road is there. Relinquish agile. So according, they have relinquished it to you.
Yes.
Yes, Mr. Shetty, now you can answer. They have relinquished, your client has relinquished.
When you applied after plan was applied after 1995 master plan. Pursuant to the government board direction, submitted a plan saying that okay, on present date 2015 plan was there. They rejected our plan saying that don't give 2015 after 2015 master plan. Your plan when you give it because the 1995 master plan was there. Give it as per 1995 master plan. We submitted as per 1995 master plan. Now the endorsement is you have to submit as per 2015 master plan. Well, every time what, and in fact, in the original plan which we submitted, you have shown 18 blocks. No, the whole original plan. You have built only 7 blocks. Now they are saying that keep this an open area. Well, this original plan is annexure B. B to the additional document. All the 17 blocks which are built are shown there. How can they be? Ultimately, as a lordship pointed out, let them take the present building.
We'll come to that later. One by one. There will be mixing up things and we'll be stuck here. The road, first let us get a clarification whether the plan has to be as per the 95 plan or 2015 master plan. Now the 95 CDP, you can't show RMP 24 meters.
Our plans of very much.
CDPL is 24 meters. CDP 95 course with you now. Yes.
The pipeline road.
Yes.
What is marked in green on the right hand side?
Where is the pipeline road shown as 24 meters?
Pipeline road on these are the top. I'm here on the right side, if you are slightly go to the other road, which is marked in green.
Yes.
In Jaga 40, which is marked in reddish color. It's not actually.
To Tumkur Road anta ide.
This is the area.
Yes.
This is the 24 meter which is shown in the submitted plan, which is according to 1995 zonal regulations. If compare this with this, this filter the road is completely reduced. The four side like this plan, this area is not indicated at all in the plan.
ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ಇಂಡಿಕೇಟೆಡ್ ಇಲ್ಲ ಅಂತ?
ಅಲ್ಲ ಈ ಪೋರ್ಷನ್ ಇದೆಯಲ್ಲ, ಈ ಪೋರ್ಷನ್ ಎರಡು ಪೋರ್ಷನ್ ಈ ಪ್ಲಾಟ್ ಇದೆ.
ತುಮಕೂರು ರೋಡ್ ಅಂತಿರೋದು ಇಲ್ಲಿ HMT ರೋಡ್ ಅಂತಿದೆ.
ಅಲ್ಲ ಈ ಪೋರ್ಷನ್ ಇಷ್ಟು ತೋರಿಸಿದ್ದಾರೆ ಅಷ್ಟೇ. ರೆಡ್ ಇಂದ ಇನ್ನೊಂದು ಲೈನ್ ವರೆಗೂ ತೋರಿಸಿದ್ದಾರೆ. ಇನ್ಸೈಡ್ ಇದೆಯಲ್ಲ ಇನ್ನೊಂದು ಲೈನ್ ಅಲ್ಲಿ ಅದೆಲ್ಲ ಸೇರಿಸ್ಕೊಂಡು ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಂಡು ತೋರಿಸಿಲ್ಲ.
We got it. You are saying there 18 meter wide entrance ಇದೆ. Width ಎಲ್ಲಿದೆ 24 meters ಅಂತ. ಇದರಲ್ಲಿ 15 meter wide existing road ಅಂತಿದೆ Mr. Reddy. Below that entrance ಅಂತ.
22.866 meters ಬಿಡಬೇಕಾಗಿ ಅಲ್ಲಿ ಆ ಲೈನ್ ಇಂದ ಅಲ್ಲಿ ಮೇಲೆ ಬರ್ದಿದ್ವಲ್ಲ 22.866 meters ಅಂತ ಅದು ಬರ್ದಿದ್ದಾರೆ.
For road widening ಅಲ್ಲಿ.
For road widening. Abhi idರಲ್ಲಿ this is updated in this present plan. That is because idರಲ್ಲಿ ಇದ್ರೆ what they will do is FIR will get additional benefit of FIR. ಅದನ್ನು ತೋರಿಸಿ ಅವರ additional benefit FIR
ತಗೊಂಡಿದ್ದಾರೆ. ಇವಾಗ ಕಮ್ಮಿ ಮಾಡಿದ್ರೆ FIR ಹೋಗುತ್ತೆ.
ಕಮ್ಮಿ ಮಾಡಿದರೆ ಅದು additional benefit ಹೋಯ್ತು. 13 ಫ್ಲೋರ್ ಅನ್ನು ಕಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ. ಇದನ್ನು ತೋರಿಸ್ಬಿಟ್ಟು ಈಗ 13 ಫ್ಲೋರ್ ನೋಡಿದ್ಮೇಲೆ based on this FIR they have already taken. Benefit of FIR they have already taken and they have picked 13 floors each tower. The towers 7 and 6 towers. 8 towers.
So this is on the eastern side.
Oh. Now they have already taken the benefit of this road for the purposes of computation of the FIR. Now they are asking for a modified plan, excluding that because that is not indicated.
So, what is the width of this road, Mr. Chetty? East by HMT road?
The plan which is given never improved.
So you're not able to tell us now, but you will be able to tell us after getting instructions.
I'll be able to because I want to that's why
Covered it. No, we'll just record this for this particular.
it will be easy for us.
Where is that?
There are other points also.
We will go one by one. We'll go one by one. Otherwise, both of you will hear and one point will record so that both of you can answer. A contention of Sri Nanjan Reddy, learned senior counsel, is that on the eastern side of the plan submitted by the petitioner, where the road is mentioned as east by HMT road, the petitioner, the said road measured 15 meters and the petitioner was required to leave 22.866 meters for road widening from and out of its property. A perusal of the plan now submitted does not indicate the width of the road, including the road area left out. That is what we are saying. Shri Shashikaran Shetty, learned senior counsel, seeks for a short accommodation to obtain instructions and make a submission, as also submit a plan showing the, as also in the plan, show the width of the east by HMT road.
What is the width of the road in original plan submitted?
The original plan of 15 meters existing to 22.5. Area of the original alva idu.
This is not the original plan. This is the plan which, because the Russian mechanic, there's no field in that.
So give us the original plan. We are given this to say it's original. We are given this saying that this is the original. Okay, in the Annexa B now.
And your Russian refer to Annexa B and answer, let both be referred to. I don't want to contradict because I'm not 100% sure it's not the identical.
According to you, Annexa B is your plan.
And my learned friend says it is according to the Annexa B.
Where is Annexa B? Page number.
List of documents filed on. Filed on October 2018. Convenience comparison.
It has been stitched, Mr. Shetty.
This plan is according to Annexa B. I'll verify that. No.
It is showing us 22,866 mm for Mr. Shetty. In this also, it is showing us 22,866 mm. That is 22.866 meters for widening and pillar.
Whatever it is, but we will abide by whatever. I'm not going on.
15 meters wide road and pillar. Then you have to give that extension. Yes. 6 point granted. I mean next. That plan only we are mentioning. It's 22,860 mm antide. 1000 mm is 1 meter. It is 22,000 meters and 22 meters. Usually 22.866 meters antiದ್ದಾರೆ ಅಲ್ಲಿ mm ಅಲ್ಲಿ. Architects always use mm. 300 mm is 1 feet. ಯಾವುದು confusion ಅದು. Yes. Hold on.
My learned friend said that we are trying to should have been open space. In this system, we are for building. But what prima facie goes to show.
We'll come to that. We'll come to that. ಇನ್ನ ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಬರೀ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್. Yes.
Block A is the G. Block factor plus 13 ನಿರ್ಮಿಸಲಾಯಿತು. ಕಟ್ಟಡದ ಸುತ್ತಲೂ ಕನಿಷ್ಠ 13 ಮೀಟರ್ ನಡುವೆ ಜಾಗವನ್ನು ಕಾಯ್ದಿರಿಸಬೇಕಾಗುತ್ತದೆ. ಆದರೆ ಸಲ್ಲಿಸಿರುವ ನಕ್ಷೆ ಓ ಬ್ಲಾಕ್ ಕಟ್ಟಡದ ಪಶ್ಚಿಮ ಭಾಗದ ನೈಋತ್ಯ ಮೂಲೆಯಿತ್ತು.
ಅದು ಹೆಂಗು ಅವರು ಅದೇ ಬರ್ದಿದ್ದಾರೆ. they will have to give explanation. Nothing more they can do. ನೋಡಿದ್ರಿ? You showed us the O block. Yes. Yes.
This is a block by itself.
Yes.
O block. This is a block by itself. It is mentioned as block O somewhere in the right hand side.
ಮೂರು ಜಾಗದಲ್ಲಿ ಮೂರು ಬ್ಲಾಕ್ ಮೂರು ಸೇರಿ
central red portion
ಅದು ಸಿವಿಕ್ ಕಮ್ಯುನಿಟಿ.
Red portion this is a block by itself.
Yes.
This is a block by itself.
ಯು ಶೇಪ್ ಬ್ಲಾಕ್ ಇದೆ.
Yes, it's a block by itself. It should have on all four sides 13 meter border. Whereas on the northeastern part of the top left hand side column,
it's only 7.10. So your fire engine clearance would be a problem.
No, this is what is the modified slab.
But there is a civic community site next door.
Yes.
So although it can be widened.
This has to be wider, that I thought.
If we shift the civic community site somewhere else,
Because to compensate another, this is only 7.5.
total measurement Amel Baran. If the 7 meters is extended to 14 meters, it will eat up into the civic community. If that civic community can be given in the open land,
That 7.5 meters remains the same. It can't be extended because there is no other space. It's all built up already.
no, civic community and civic community building area. Civic community building area.
They are not applying for plans like for whole block at all.
Is it constructed or not constructed?
Constructed, but OC has not been applied, not subject to
No, the entire project is subject matter of this writ petition. You can't split it. If you are going to split it, then we will dismiss the petition.
No, we have no problem.
You take the entire project or you don't take it at all. Who are you for, Mr. Now you want the developer to answer or you are going to answer on behalf of the developer? You will have to make a choice. Because there is a conflict of interest. If suppose some order is going to be passed, we are putting you on notice on that. If suppose an order is passed, you will have a claim against the developer. But if you are going to support the developer, then you won't have a recourse against the developer. No, you can argue anything you want, madam. Whatever you want to argue, you can argue. But once you support, then you are complicit in that. So you can't have a claim against the developer. You make your choice. You elect what you want to. You want to support the developer, please support. You are for Mr. KP? For whom? For whom are you?
I've been period as respondent for 5 years. We are specifically opposing it. Just to put it in perspective. We will have the
So we'll observe that so and so is supporting, so and so is opposing.
Lord, I appear.
We are concerned with the entire project material. If there is a violation in one part, there is a violation everywhere. We cannot distinguish the violation in one place from the other. So if block O there is a violation, block O will be demolished if it cannot be saved. If there is a saving that Mr. Shetty can come up with a solution for, we'll try and save it. But if there is a violation to such an extent that it cannot be saved, then it will go the same way as Coca-Cola or Super Sem or what is the project in Kerala? Cochin. The 3 projects are examples, so it will go that way.
This is the objection that they coming up finally. Because
We are making note of all the objections so that you answer.
no, because every time I just pointed every time there's a new objection which is already raised by the authorities concerned.
We'll record today that apart from this objection, Mr. Nanjan Reddy has no other objection. All your objections, please place it on record, Mr. Reddy. No further objection should come later. Because once your objections are there, they will answer. Whether they are able to answer or not is their lookout. If they are not able to answer, if they are able to answer,
If there are anything, I will bring it to
We'll have it on Thursday. 2 days ನಿಮ್ಗೆ ಆಗುತ್ತೆ. Day after tomorrow. ನಾಳೆ ಒಳಗೆ ನಿಮ್ಗೆ ಆಗೋದು ಕಷ್ಟ ನಿಮ್ಗೆ. ಒಂದೇ ಸತಿ ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ. We'll put it across to Mr. Shetty. We'll give you 1 week's time to answer.
It's so outside.
If you don't want to do the exercise, Mr. Gulbar, you're welcome not. You can oppose the exercise, and if the exercise doesn't happen because earlier orders are there.
I can also tell you, if I'm not able to answer, I point out to you what answer for it, and there is no violation. The executive engineer comes before the court, inspect, finds everything, he finds the thing, there is no violation. Court says, as per that, you grant plan sanction. That is why I made a submission every time a new objection comes. And in respect of this, I keep a reply. I can give all the, give me a week's time. File an affidavit to show there is no complaint, but any defect, if there is any defect, what's the solution to the defect also?
Yes. Then we'll see whether they are agreeable for that solution, and then what happens. What is that? When it comes to arguments, so you also want to point defects.
PDA is a part of the law. The simple reason, one example I give you. The relinquished civic community site has been included as the land area, as is there only the same section of A, B, and C. They have mentioned it as the land area and given us and sold us undivided share in that. Therefore, there is much more than this. As far as the whole crux of the issue is not got it right in the beginning, not said. The entire land area and the FAR based on the land area and the built up area. 3 figures basically.
Road extent, FAR, land area, constructed area.
That's the crux of the issue. With a slight twist to that, to the extent that some of the same things with regard to, not some, all same things, with regard to particularly the building block O, shows a certain area which includes the already relinquished civic community site.
You are in which block?
Block O.
That's why now we understand where you are coming.
So we will put forward.
And now we understand where Mr. Girdhar is coming. So they want to put everything on you and say there this one, and you are into a problem, so you want to save it.
That is a different project where partial occupancy has been granted, there's permission. Here, one of occupancy is applied only for this, and that is an independent of this block. I'll point out that.
We will go by the direction which has been issued earlier, that the entire plan which you have submitted,
Correct.
we will look at.
But as per the plan sanction submitted.
But we are not distinguishing.
As per the plan, sanctions submitted from time to time.
Absolutely, from time to time.
Till now.
Absolutely, I stand by that. Time to time, for example.
Unlike them, we are not saying, we are saying who is part of the overall entirety of the project.
We will be considering the entire project as one.
What they are saying, that's why I wanted to make it clear, because the Lord said, not have this apprehension that could be here, there's a different kind of tango going on. No, Lord, we say quite categorically that we treat the entire project A to O, all the blocks as a single unit, as a single project. And based on that, our FIR also be determined, and that whatever extent has been conveyed, whether that is properly conveyed or not, will be the subject matter of our submission.
So you also want to point out what are the defects in the plan sanction and the as-built. No, day after tomorrow. We're having it day after tomorrow.
Yes, we do.
Shri Nanjan Reddy, Learned Senior Counsel, appearing for the BDA. And Shri N. Petty, Learned Counsel for Respond number 5. seek for and are granted 2 days time to point out the defects defects and or violations of the plan sanction. Shri Shashikaran Shetty, the senior counsel appearing for the petitioner, would submit that once the defects are pointed out, if he is granted 1 week's time, he would answer all the same, or all the said contention. Released on 7/7/2022 at 2:30 p.m. for the submissions of Shri Manjan Reddy and Shri NKT. You will file it in form of a document or for the filing of an affidavit.
The copies to the others.
Copies will also.
Instead of producing the documents, you produce along with these documents, along with an affidavit and write the order.
Yes.
We'll try to do it.
It is made clear that the objections to be raised by either the BDA or the clients of Mr. NKT shall be final, and once the same are placed on record, no further objections would be entertained. Vachan irlilla anta pasu. Yes, Mr. Charity, where is Mr. Vachan? Inna argument ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರ ಪಾಪ ಇಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ. Come out of the screen.
ಇನ್ನು 17 ಹೋಗ್ತಾ ಇದೆಯಾ?
Mr. Vachan is not here. In person of the order dated 7/6/2022, the Registrar Judicial has submitted a report enclosing a memo issued directing all officers and officials working in the judicial side to oppose all objections, be it on interlocutory applications, from a statement of objections, from objections to the interlocutory applications, from objections on memos, from a process fee, etc. The said memo and the said report and memo is taken on record. The Registrar Judicial is directed to supervise the implementation of the said memo. Though learned counsel for the petitioner is present and ready to address his argument, it is submitted that learned counsel for respond number 1 and 2 is on his feet in another matter. Released on 19/7.
Please, my lords, for the petitioner in this case.
Who appears for the BDA?
The lordships had directed the registry, my lords, to keep the law officer present. What has happened? BDA.
Mr. Igde, you are appearing for the BDA now? You are appearing for the BDA now. Shri SG Egde has entered appearance for the respondent. In registry, is directed to delete the name of Shri Ramakrishna as that appearing for the respondent. Yes. Who is present? Now we want to know why it takes such a long time for issuance of a wakalatnama and filing of objections. Why it takes such a long time for issuance of even a wakalatnama? What is the communication? Who is to issue the wakalatnama? So why does it take 4 weeks or 6 weeks as in this matter? Notice was ordered on the council on 1/6. Even on 23/6, no wakalatnama was filed because it was submitted that wakalatnama has not been received. Early communication gap. Yarinda. ಎಷ್ಟು ದಿನ ಬೇಕು ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ? ಎಷ್ಟು ದಿನ ಬೇಕು ಅಂತ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. ನೀವು ಆನ್ಸರ್ ಮಾಡ್ತೀರಾ, ಅವ್ರು ಆನ್ಸರ್ ಮಾಡ್ತಾರೆ? Law officer, how long does it take to allot a matter? So when did you interest? And why was the wakalatnama not filed? Wakalatnama ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದೆ? ಅಲಾಟ್ಮೆಂಟ್ ಅಲ್ಲ, ವಕಾಲತ್ನಾಮ ಯಾವಾಗ? When was the wakalatnama given? Which officer has to sign? So why does the deputy secretary take 15 days for signing a wakalatnama? Is the deputy secretary here? Why does it take 15 days for signing a wakalatnama? Not acceptable, Mr. Aguilar, not acceptable. The timelines were fixed for filing objections. ನೀವು ವಕಾಲತ್ನಾಮನೇ ಹಾಕಲ್ಲ, objections ಬಿಡಿ. And why so many changes in wakalatnama? Matters are pending from 2014 without objections being filed. That was only now, but why has the objection not been filed in the last 6 years? There cannot be an excuse, Mr. Law Officer. 6 years you can't take to file objections. The courts get blamed because there's a delay anta. BDA is ಮಾಡ್ತಾ ಇರೋದು ಯಾರು ಗೊತ್ತಾಗುತ್ತೆ? Who is to blame for the delay now? We are trying to push you to file, you don't file. And because you are the statutory authority, we are a little liberal. We started imposing costs, then we are told the advocates have to pay it from their own pocket, and we stopped. So now, henceforth, if there's a delay, we are putting you on notice. We'll impose costs to be paid by your law officer and the deputy secretary. So who is the person who is allotting and so we'll impose cost. What is the designation of that person? What is the designation of the person who signs the wakalat and allots? We'll impose cost on the deputy secretary. And in most cases, only appearance is made for land acquisition officer. Nobody wants to represent your commissioner because they don't have wakalat. So commissioner ex parte place madana. So who is the person who has to sign a wakalat? Next time namge reference we will impose cost on that person. Yaro. Yes, Mr. Charity, what do you want to say? So deputy secretary has to sign the wakalat.
They are all authorized to sign on behalf of the commissioner, unless it is
Personally. No, the only question that we are asking is, we don't want to impose cost on the advocate to pay the cost from their pocket. So who is the person responsible for the delay? ಅಷ್ಟೇ ಹೇಳಿ ನೀವು ಇದೆಲ್ಲ ಬೇಕಾಗಿ ಅದೆಲ್ಲ ಇಂಟರ್ನಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಏನಾದ್ರು ಮಾಡ್ತಾರೆ. ಫೈನಲಿ ಸಿಗ್ನೇಟರಿ ಯಾರು? The law officer or the Bangalore Development Authority is present. He is present in person. He submits that though the allotment that he received information about the above proceedings and the notice order on 13/6/2022 and immediately allotted the matter to the concerned advocate on 15/6/2022. However, the signing of the wakalatnama was delayed and the wakalatnama was finally issued only on 30/6/2022. He submits that the necessary instructions, that it is the deputy secretary of the concerned department who is required to sign the wakalatnama, since the wakalatnama is not signed by the law officer. On inquiry as to who is to furnish instructions for filing of statement of objection, we submit that it is there are 4 different deputy secretaries heading 4 different departments, apart from 4 different SLAOs, land acquisition officers, who are to provide the instructions. They collect the same from those officers and transmit it to the concerned lawyer. He submits that the delay is on account of the delayed instructions from the concerned deputy secretaries and or the SLAOs. This court has been listing several matters on a day-to-day basis in which matters are being adjourned repeatedly, either for filing wakalatnama or filing of objections. Many of the matters pending before this court are from the year 2013 and 14, where objections are yet to be filed and adjournments are being sought for. The delay in disposal of this matter is squarely attributed to the offices of the bank, above said offices of the Bangalore Development Authority. The said officer, the commissioner, Bangalore Development Authority, is directed to instruct the said officers to execute and forward the necessary wakalatnama at the earliest, at any rate within 2 days of information being received, notice being received, and furnish instructions on the same within a period of 1 week after the information is received. it is made clear that if there is any delay in filing of the Wakalatnama and or the objections, this court would impose costs which would be payable by the concerned Deputy Secretary and or the concerned land acquisition officer. The law officer is directed to bring the above order to the notice of the Commissioner as also to the concerned Deputy Secretaries and the land acquisition officers. Correct. In the present matter, Shri S.G. Hegde, Learned Counsel, who has entered appearance on 30/6/2022, submitted. Yeah, we received the Parawise comment Banta. Submit that he is yet to receive the Parawise comments. Though notice had been ordered by this court on 1/6/2022.
21 minutes.
1/6?
21. 1 year ago, notice was ordered.
On 29/6/2021. And repeated adjournments have been sought for by the BDA. And finally, this court, by order dated 1/6/2022, had fixed 16/6/2022 as the final date for filing of objections. Thereafter, the said counsel has been changed and a new counsel has entered appearance on 30/6/2022. Though there is no indulgence required to be extended in the matter, at the request of Shri S.G. Hegde, 2 weeks' time finally is granted for filing of statement of objections. If statement of objections are not filed by 21/7/2022, costs of rupees 50,000 would be imposed. Released on 26/7/2022. We'll inform you beforehand only. And this will be in all 5 numbers only.
With all due respect, Mr. Report, may in this case, may remember 8714. The matter of this case is 40 years back. The same which has given to the BDA has not come till today.
We'll take up your matter when it reaches. ಅಲ್ಲ ಅದು ಬಂದಾಗ ನೀವು ಹೇಳಿ ಅವಾಗ ನೋಡೋಣ. ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಈ ಮ್ಯಾಟರ್ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಆಮೇಲೆ ನೋಡೋಣ. ನೋಡ್ತಾ ಇದೀವಿ ಅದಕ್ಕೆ we are being a little harsh. You may feel we are harsh, but can't help it. We list on 26/7.
Public.
So you filed impleading application. We not passed orders on the impleading application. We passed orders on the impleading application.
Those who allotted from the last applications are considered they were after the passing of the implement.
Yes.
But the 2 applications.
They already said that the application kept pending only to consider them in the event of the petition failing. They already passed an order.
Please observe that it is in violation of the implement of this honorable court.
So what do you want, Mr. Counsellor?
Someone records so that I
No, we won't permit you. We already observed that. Orders have already been passed.
This is a fresh application we have placed now.
So more number of transactions.
These applications prior to passing the I have been allotted prior to the implement being passed by this. On the last day.
So you are on IA1 now? Which IA are you speaking of?
Those 2 IAs are not put up today, but it is brought on record.
Then if they are not put up today, why are you arguing the matter, Mr. Counsel? Why are you confusing me?
They are not putting up.
So we'll direct them to put up. Why are you arguing the matter? Make that submission. Your implementing application, you have the 1 of 20 and 1 of 21 with the other orders already made. So, a number in my IS.
2 of 22 and 3 of 20.
Shri so and so submit that he has filed IA number 2 of 22 and 3 of 2022. Registry is directed to put up the same. You are ready to address item, but now these applications are there. You want to file objections to it? Until this is sorted out, we can't hear you. Counsel for the petitioner seeks for and is granted. Copies for the counsel for the petitioner acknowledges receipt of the copies of the application. You have any objections, Mr. No. Nimmalati. Counsel for the petitioner seeks for and is granted 2 weeks time to file a statement of objection. Objection is finished by 21. We list on 26. Interim order earlier granted is extended to next day. Correct ಆಗಿ ಹೇಳಿದ್ರೆ 1 ನಿಮಿಷದಲ್ಲಿ ಆಗುತ್ತೆ. Yes. No order. ಹೇಳಿದೀವಿ. BDS files our state is yet to file. So BV Krishna seeks for 1 week's time to file objections. Our BV Krishna. Your BDA girls, your media. So supposed to be filed on 36. Nimmal yar cost impose mode.
That's the issue.
2018 matter inna ನೀವು objections ಆಗ್ತಿಲ್ಲ. First day ನಿಮಗೆ before filing service ಆಗುತ್ತೆ. 4 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ? ಕಷ್ಟ ಆಗುತ್ತೆ. How do we give you time for more than 4 years? But HCGP seeks for and is granted 2 weeks time finally to file a statement of objection. If objections are not filed, cost of rupees 25,000 would be imposed. Payable by Yara, respondent number, represented by Yara. Who is respondent number 1? Payable by Secretary, Urban Development Department. ಅಲ್ಲಾದ್ರೂ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗತ್ತೆ ಆಮೇಲೆ ಇಲ್ಲಿ ಎಷ್ಟು ಡಿಲೇ ಆಗ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಗೊತ್ತಾಗತ್ತೆ ಡಿಲೇ ಆಗ್ತಾ ಇದೆ. then they will instruct you. ಇಲ್ಲಾದ್ರೆ ಏನಾಗಲ್ಲ. The secretary may not be in charge of it. Day-to-day running is by so many others. ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಆಗಲ್ಲ ಆಮೇಲೆ. So ಇದು SCGP is directed to bring the above order to the notice of the Principal Secretary, Urban Development Department. Yes, madam, what happened? Correct, yeah. ಎಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದೀರಾ ಮೇಡಮ್? ಇವಾಗ ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ then we will ask you to make payment in terms of sub rule 1 of rule 13 of the allotment of site units. correct calculate ಮಾಡಿದ್ರು ಕೊಡಕ್ಕ 4 months. Why are you depriving him? 3 months. March and July. 3.5 months. So another 3.5 months, when will you give? Next week. Okay. Counsel for the respondent has today handed over a demand draft for sum of rupees 44,41,966, bearing number 573785, drawn on Canara Bank, BDA Complex Branch, Bangalore, dated 26/2022. The counsel for the petitioner submits that the said amount is the calculation of the said amount is as on 15/3/2020. 15/3/2022, and submit that he would receive the said demand draft subject to the balance amount also being paid. And counsel for the respondent submit that given a week's time, the balance amount. 7/6/2022 was the order, madam. You are calculated in March. So 7/6 ನೀವು ಕೊಡಬಹುದಾಗಿತ್ತಾನೆ. You could have given it on 31/5 also. This on 31/5 when the matter came up, you sought for time for instructions. So if this DD was ready, you should have handed it over on that day. Then it came up on 7/6. 7/6 sitting ಇತ್ತು. DD ಕೊಟ್ಬಿಡ್ಬೋದಾಗಿತ್ತಲ್ಲ ನೀವು ಅವ್ರಿಗೆ. 2 days when the matter came up, you did not give it. ಮಾಡಿ ಅದಕ್ಕೆ interest ಕೊಡಿ within a period of 1 week. So what do you want to say? You are going to consent or you want to order? And counsel for respondent submit that the demand draft was ready in June 2022 itself. However, the respondent awaited the matter to be listed for handover of the demand draft. Correct. Even if the said submission is accepted that the demand draft was ready in June of 2022, on 20th June 2022, what was required was that interest be calculated at least till that date. In the present case, the interest has been calculated as on 15/3/2022 and not as on 26/2022. Therefore, I am of the considered opinion that interest for that period is also liable to be paid by the respondent. Relist on 19/7/2022 to enable the respondent to make payment of the amounts, interest amount calculated from 15/3/2022 till 19/7/2022. The demand draft, the aforesaid demand draft is handed over to the counsel for the petitioner subject to his submission. Sign my. Here, we will take your signature. Receipt, Barber. If they have not received, it can't. Then a counsel for the respondent seeks for and is granted a week's time to produce the acknowledgement of receipt of the notice by the petitioner. Relist on 12/7. Who appears for the petitioner? No? For the respondent. For the respondent. DP present. Mr. Charity, who appears for 110 listed? Yeah. He is on the panel. Illappa, panel illa. ನೀವೇ ತಗೊಂತೀರಾ? So anyway, you are appearing. 110. Shri DP Prasanna is no longer on the panel of the BD and Shri Murugesh Charity accepts notice for respondent number 1 to 3. 110.3. Then AG accepts notice for respondent number 3. 110.6. Shri MV Charity has entered appearance for respondent number 1 and 2. Registry right delete the name of Shri GM Chandrasekhar. 110.7. Who is going to appear? Shri MV Charity has entered appearance for respondent number 1 and 2. Delete VS Sachin. And 10.10 Yaro. Prasanna Jiara Bhanumatina. 10.10. Whose office are you from? In senior SLN. The Prasanna GR has entered appearance. Registry direct delete the name of Bhanumati BC as that appearing for the petitioner. Yes. Yes, Mr.
Not protect alternative land. Demarcation of the sites bounded by land.
So not connected. 110.9. Is it connected to this 100%? Not correct. Both the councils submit that WP number 44544 of 2016 is not connected to the above matter. Then the registry is directed to dealing the said matter and relist on 19/7. Objections hakidira? Objections to be filed within that time. The rest are all part of the same group. Yes, Mr. One will hakidre ella same, Mr. Question of law. Unauthorized use, payment of compensation as on today, along with rental compensation, along with the mean profits and damages.
Look, I understand what you're talking about, but I would be able to pursue because on the basis of very similar matter, very similar matter. So what happens about this? When in respect of some land users, 100% was given. Based on that, some of them came before this court. Here, if you also see, the petitioners have not challenged the either taking of their land or whatever. They were given land. All that they are in all the petitions, in most of them, they are asking for 100% after taking some of the sites which were given to them. Look, may I just submit these things before your lordship on the principle of law and what has happened.
So allow me to make my position.
Please,
Petition.
please.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದ್ಬೇಕಾಗಿಲ್ಲ ಐ ಆಮ್ ಡಿಫೆಂಡಿಂಗ್ ಅಂತ ಯು ಆಲ್ರೆಡಿ ಸಕ್ಸೀಡೆಡ್ ಇನ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಮುಚ್ಚಿಕೊಂಡವ್ರು ಸೊ ಅವರೇ ಹೇಳ್ಬೇಕಾಗಿರೋದು ಅಷ್ಟೇ. ನೀವೇನ್ ಹೇಳ್ಬೇಕು? ನಿಮ್ ಲ್ಯಾಂಡ್ ಆಯ್ತು, ದೇ ಹ್ಯಾವ್ ಯೂಸ್ಡ್ Your submission is only that much. So our explain model.
What has happened? These lands which have been taken their cost. But it is not as though BDA has suddenly gone and taken away the land by forcibly. This is not by compulsory acquisition of land, but BDA was a provision by agreement. Now, we had told them that we will give so much compensation for taking the land, for which we had agreed. So in most of the cases, sites have been given. Now, what happened was this was deeply done. Earlier, there was a resolution passed by BDA that if you utilize the land, 50% will be given, some about 75%, some about it was then a resolution of 100%. Then ultimately there were matters which were there, and the matter was referred to Secretariat Committee. Then the Secretariat Committee, then the government said you cannot do, you have to give them cash. Then the matters came up before the Honorable. But the first case, is the Arunachalam's case, where this Honorable Court said that the value of the land is to give. But at the outset, I have to submit. But that BDA is not doing any charge. But the land has been taken, we have to pay them the compensation. Our only contention is that neither there should be any unjust enrichment, nor there should be any empowerment for them. So whatever is just an equitable compensation that should be given to them, that should be given. That would be my submission before your office. So
Mr. Kannur, the first thing that you will have to answer is, did you acquire the land in a manner known to law, either by way of exercising powers of eminent domain or power of entering into a sale agreement or a sale deed or any manner known to law?
They have, in fact, what is happening now? Some of those stages are passed because they have not entered into relinquishment deed. They have been allotted land. But they have not challenged. No, they are not coming before this Honorable Court with a prayer that we want our land back. That is not their prayer.
Imagine the situation. Imagine the situation if they come like that, Mr. Kannur. What would happen?
Let them come. Because what we have given them, that's what the division bench said. The Honorable Division Bench, when we brought this to the notice. In fact, their argument before the Honorable Division Bench in writ up in 697 was that since you have given 100% to the other people, you give us the same thing. That time, I had argued to the Honorable Division Bench that there cannot be any negative equality, nor if an illegality has been committed, it cannot be perpetuated by asking media to give. But that was upheld by this Honorable Division Bench. The order of the learned civil judge was set aside, against which my lord will file a review petition. Review petition this is all that we filed. Yes, all the synopsis and judgments are given. Which they said that review petition also. The review petition came to be dismissed. But then the synopsis of judgment, the first one,
yes,
that is at page 9.
Yes.
So this, if your lordships were to turn to page 9, internal page 17, but here the case was very similar. And in page 19, internal page 11, para 11, thus in substance, she is showing to the various allotted equivalent area of land to the land of the several cases. These also were similar to the land taken by VDA. Look here, in fact, we had given them sites. In fact, what we had given them the sites, the amount was more than what they were entitled to. More than the value of the land.
what happened to this judgment in
Now,
6
you
months?
have to kindly see the review petition, my lord, at page 30.
Yes. It's no comment.
And what also had happened was, look, there was one more judgment of the division bench, which the Lord said contrary to this division bench. But there, the Lord, the review petition, the Lord, the honorable division bench said that there was no law data. And even otherwise, now, the Lord, against that judgment, we have filed a SLP, and that which has gone against us, the Lord, has been stayed. I have produced that also. Yes, the Lord, but now against this judgment, they have now filed a SLP in the year 2022. It is an FR number, so there is no order that has been passed. There is only on a diary number. It is the SLP diary number 18284 of 2022. Now against the other judgment also, Lord, we had filed an SLP. There is an interim order of stay, and Lord, apart from that, after this judgment, Lord, what happened was one more batch of matters came up before the Honorable Chief Justice. Lord, this judgment was brought to the notice of the Honorable Chief Justice. Lord, the Honorable Chief Justice notes, however, does not distinguish nor will not refer. But order contrary has been passed against which Lord BD has gone to the Supreme Court. And the Honorable Supreme Court has granted status quo where Lord we don't have to give them the land. That also order copy are produced. But apart from all these things, Lord, the one which has attained finality till now, Lord, is Arunachalam's case. That if your lordships were to turn to in the list of judgments, 113, Lord, your lordship may kindly see. This holds the field as
1130.
113.
113. Yes.
But here, I will not trouble your lordships with the other aspect and straight away take your lordships to.
This is the order of a single judge.
Yes. Now,
So
that's
can
the
it
reason.
finality?
This was subsequently followed by the other learned single judges. But if your lordship sees but your lordship may kindly turn to 115.
Yes, the directions.
Yes. The petitioner shall submit a detailed representation to the DDA within 2 weeks from today with the necessary supporting documents for the purpose of showing the market value of the land in Issuance. There appears to be some dispute regarding the extent of the petitioner's land. Yes, sir. Here they say for the purpose of showing the market value of the land in 2008. Then it appears to be some dispute regarding the extent of the petitioner's land utilized for various purposes. The petitioner shall produce the necessary documents in support of the state that the land used by VDA actually measures 3 acres. On consideration and on hearing the petitioner, VDA shall arrive at the determination of the value of the land as well as the measurement of the land in question. If the VDA wants to give alternate land in lieu of cash compensation, it must indicate the value of the site to the petitioner. It's open to the petitioner either to accept the offer of the VDA or not to accept the offer or to accept the offer of the VDA only in part. Meaning the petitioner may take some alternate land in respect of the portion of the acquired land and insist for the payment of the compensation in respect of other portions of the acquired land. The respondent VDA shall also award the special damages to compensate the petitioner for illegally occupying the property for the last 4 years. If the petitioner is not satisfied with the order determining the
That will
market
last 4 years from the date of occupation till date of judgment.
Yes. Now this.
So here it will be till 2022.
No, now and determination of the thing. Now the Honorable Supreme Court has very clearly held it cannot be under the 2013 Act. The compensation has to be fixed under the old Act. The latest Supreme Court judgment is the last judgment. Your Lordship may kindly turn to page that has now been upheld by the Honorable Supreme Court. Page 164. Page 164. The last parameter at page 177, either than page 14. In view of the above, the learned judge of the High Court in so and so was not justified in holding that the provisions of LA Act that are made applicable to the BD Act are in the nature of legislation by reference. The learned judge also heard in holding that in view of the repeal of LA Act by coming into force of the 2013 Act, the corresponding provisions of 2013 Act would regulate acquisition proceedings under the BD Act, and that this would include determination of compensation in accordance with 2013 Act. It's hereby clarified that since LA Act has been incorporated into the BD Act, so far as they are applicable, the provision of 2013 Act are not applicable for the acquisitions made under the BD Act. Therefore, the judgment of so. Now, my lord, what happens is this. Because now the honorable division bench, which I pointed out, but that review petition now, they have filed an SLP member, that is FR number, because it was the year 2019 and 2021 review was dismissed. Now they are filed because there is a delay, that's why that FR number. Now the other division bench ruling about which they were relying on earlier before the learned singer had come up, which was just the matter had come up. That time the question was which judgment to be followed, whether the latter judgment of the Honorable Chief Justice or this division bench, which has to be followed. But our argument was simple that since that matter.
What is the order? What is the order?
What?
Submissions better. Order it.
Page 94. Page 94.
Yes.
So here also, my lord, after considering all these matters, now, para 6 is the lordship may kindly turn to internal page 9, in page 100.
More or less the same thing as Arunachal.
Yes, now Arunachal, what happened? Coming to that, then subsequently after the Arunachal judgment, the learned singer judge will not follow that judgment. Subsequently also, the very same learned judge follows that judgment. Against which may not BDA prefers the writ appeal. The writ appeal may not come before this division bench, and that matter may not is at page 148 blocks, may kindly term.
Yes.
But writ appeal is filed by BDA, challenging about the order of the learned single judge, who had followed Arunachalam's case. But our appeal may not claim to be dismissed. Against this, we filed an SL, page 152.
That has also been dismissed.
That's also dismissed, thereby confirming the principle laid out in Arunachalam's case. I would not say that Arunachalam case itself, because the directions were extracted by the learned single judge of Arunachalam's case. So this has been confirmed in the order of the Supreme Court that this is how it has to be given. So we are not saying.
No, it is not said in that matter that this is the only way to be given. What is done in that matter has been approved.
Now what happens is this. Now 100% of how they are claiming and how they will be adjusted. No, but the land what we are taking about is the agricultural land. No, when we give them, we are not giving them an equivalent agricultural land. No, we would be giving them developed land.
How did you take that land, Mr. Kundra? That's the only question we asked you.
For the formation of the, then what happens?
Not what. We asked you how you took it.
Look, it is not as though that we have forcibly entered and taken it because they themselves have not come before this court as to why they took our land.
You are to
should give us compensation.
You have used the land is admitted.
Absolutely.
On what basis did you use the land?
Not for the formation of the road.
What basis? Again, you are going to what?
No, they agreed to give the land.
Where is that agreement?
No, they are relinquished. They are.
Show us those documents.
Yes.
We'll come case by case.
No, that they have each facts about the.
You show us where out of these matters the consent by the petitioners, they are out. They'll go by the terms entered into between them.
Now, what happens in this? What the lordships are asking is whether whether we have entered into an agreement with them or not. Now, relinquishment is there. But now, when they execute a relinquishment deed, that's what I'm saying. In most of the cases, already some lands have been given to them. They have taken 50% of the land, that is, sites have been given to them. After that, they are before this honorable court, like what I said before, the honorable division.
Mr. Kanna, that is like, take this. After they take it, then they can't come to this court.
No. I'm not on that point. But that is how they have come before this honorable court in so many matters. This is not this
No,
honorable
Mr.
court.
Kanu,
What I'm trying to say is, the value of the land, that is why I'm saying, Lord, we would bow down to the lordships with whatever your lordship says, whatever is the just and equitable compensation. Lord, what we are saying is, they cannot be given, Lord,
we are
100% the value of the land.
We are concerned with two things. You are not there when the matter was argued.
I was informed, Lord, that your lordship has said, on what basis did you take?
Still, you have not answered that.
Look, that is because.
Just a moment. Please hear us out. First is, on what basis did you take the land? You have to answer that. Without answering that, please don't go into all this valuation. We are not happy with the valuation. You won't get impressed by the valuations. Because the simple reason is that the BDA had no business to take over a land of a private person without. Please listen. If you want to listen to understand, you can understand. Otherwise, you want to respond, we won't even ask you a question. You can continue responding. We'll draw our inferences. We are giving you the opportunity to answer that. On what basis did you take it? Did you do it legally or did you do it illegally? If you did not do it legally, you have done it illegally. Now, if you have done that, did they accept your illegality and agreed to give you the land on receipt of certain money or certain sign? If they have agreed, they are out. If they have not agreed, no matter of your saying any valuation will be able to clothe your illegality with legality. It continues to be illegal even today.
Then, my lord, I got. Now, if the lordship see, with regard to my lord, that may I just request the lordship to turn to my lord, writ 10245. Sorry, writ petition 1025 of 2016. Writ petition.
10. CL number. What is the CL number?
1025. 10245 of 2016.
110.5. Yes.
So your lordship may kindly turn to the prayer.
Yes.
At page 7.
Balance
issue a writ of mandamus or any other writ of similar nature or order directing the respondents to allot balance extent of 50% of the alternate site in lieu of utilization of her land, measuring 4.4 to 2000 survey number so and so, H1 so and so, as demanded by the petitioner by annexure 3. So we got here now the question of we not entering into an agreement on that, that question cannot be gone into in this situation.
Why?
Their own prayer is that you give me balance 50. They've taken 50, so they are not challenging anything. All that they're saying is you give me the other 50%.
Because you are not given. What else do they have to challenge? What do they have to challenge?
I'm not saying that they cannot challenge.
No, what do they have to challenge?
This is the answer to your lordship's first question.
What do they have to challenge?
Your lordship said, your lordship said that if even there is an illegality committed and they have allowed them to take the land, but here they have allowed the land to be taken.
They have allowed by saying give us 100%. Give us the 100% of the value, same land. 50% you are given.
50% what was to be given to them. They are now saying that because that's why I was trying to point out that they are also the honorable division bench. Their argument was in some matters, what happened.
No, Mr. Kannur, please don't give us what argument happened.
Here in this case,
please argue this matter.
Some of the matters, relinquishment deed we cannot produce because here that was not necessary for us because their prayer only was to allot balance 50%. Now, if you were to allot the balance 50%, if that is going to be unjust enrichment, then this court cannot allow that to happen. And ultimately, what is the thing is the value of the land that has to be given. They have not sought for that prayer itself. Where is the prayer of them asking for that? In acquisition proceedings, they challenge the very same acquisition, illegality, and all that. The acquisition is set aside, or if an award has not been passed, this court will say that you return the land to them. Even if you have done, you return the land to them because you have done. Here, that is not the case. We have those copy of the relinquishment deed that we will produce for your lordship. But my only contention before your lordship, all these matters, my lord, in this number of this litigation, it was the same issue before this honorable court. And this honorable court cannot has, because everywhere the prayer was that. This honorable court cannot ultimately, there's one more honorable division bench judgment that also are produced, where what this honorable court says, the value of the land that has to be given. But we are not saying that the value of the land is not to be given or whatever compensation is not to be given. But they cannot say that it has to. In fact, what media has done is wherever there is compulsory acquisition, if now if they are giving them 9,000 and odd meters of land in lieu of that, in respect of these kind of acquisition for the formation of road, then 11,000 and odd has to be given. Or may even make this sufficient. If they want their land back, then they should return whatever they have got. We will be able to show their logic what they have given them is more than what they are entitled to, even if there was a proper acquisition.
If they give back their land, whatever they have received, you are going to give back their land? Is that your submission?
No, what I am saying is, they will not be able to.
Do you want them to return it? We can put that question to them. If that is your submission.
That would be definitely because if you have formed the one, it cannot be possible now. But
you cannot take that in that difference.
I will not do that. I will not make that.
If you say that they let them return, I will return. Then we'll ask them if they return, you will have to return. That's all. Why too many returns will happen? Indian illa. Mugito. Potpudi. We'll accept your submission.
That if they were ready to return, we will give it back.
No rhetoric.
Because it was more of a thing not to be taken as a.
We don't want rhetorical arguments.
Yes, sir. So now the only thing is
whatever you argue, we'll accept it at face value and we'll deal with it. If you say this is the offer to be made, we'll ask it. Then you are bound by it because you are the offerer, acceptance as the contract complete. Offer is yeah.
Now, so the question is, as
ಇವಾಗ offer
back to the question posed by your Lord.
ಇವಾಗ ರಿಟರ್ನ್ ಮಾಡ್ತೀರಾ ಏನು ಇಲ್ವಾ ಕ್ಲೋಸ್ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಡಿ
Only to this was this remark is made to show that what they have got is more. So it is in that circumstance.
They are ready to return it to you. How can you say it is more?
That they may not now as a rhetoric here they may say that they don't want or they may say because in other places what they have shown because the land that has been you can also kindly see the diligent judgment.
Mr. Kanu, you are arguing this matter, not other matter. Please argue this matter.
This matter is on the basis of what the honorable division bench of this honorable court has said. What has been confirmed with the honorable Supreme Court. Only one thing about what now the judgment on which we are also relying on. Because that they have challenged before the honorable Supreme Court. Because there it is on the FR number. Because that is there before the honorable Supreme Court. In all these matters, there is nowhere that we have gone and asked for like whether there is the agreement as the lordships are saying. But since they, as the lordship said, that if they have come forward and they have given the land, because now have they said that we never came forward to give the land. If they say that you have not come forward to give the land, they have taken it. But then I can understand. But now since this is the prayer, then I will also produce a relinquishment deed in the.
You want to refer to this 10245? Please read para 2.
Yes, sir. Issue order is ongoing.
Para 2 of the petition. Para 2 of the petition.
Yes. The petitioner had resisted the illegal formation or wrote the respondent at the time of respondent realizing their mistake. Called the petitioner for negotiation. Assured for allotment of alternate equal to the layout formed by them. The petitioner, considering the request and assurance given by the respondent, has agreed for the proposal. So now
what is the proposal?
Now, can it be said? One way it cannot be said that there is no agreement. Second, you have to say that there is an agreement to what now where is it shown that it will be so much will be given? Now the honorable court has said that you cannot give so much.
Where have you said that? Where have you said that you have give only this much?
In the relinquishment deed, and when they have come forward,
then produce the relinquishment.
What has happened is this, as I said.
Then produce the relinquishment deed and argue. Don't argue until.
Because this itself would answer that they have agreed. They have only given.
Mr. Kannur, you are again doing rhetorical argument. You want to produce. You want to argue, please argue. Then after that, don't say I'll produce relinquishment.
No, produce that.
Then argue after production.
Because they may also be one more section. Look, there may be some more of this expedition. But
What do you list for it?
if all of them, what will happen is this. Because as I said, similar matters when it came to the learning single judge, that time these matters were not listed. So there one order was passed by the learning single judge and now
You are the master of all this. You give us a list.
All the matters are listed and your lordships can
And you produce whatever documents you want to produce by next day, we will consider it. After arguing for some.
My case, you have not to receive 50% of the land or any compensation. Completely different from the rest.
That on facts will only on the principle.
Let Mr. Kannur have the benefit of producing whatever he wants to produce. We will consider it that day on a fact-to-fact basis for each matter and pass out. If there are any difference, otherwise we will club them together. After arguing for some time, Sri Gurudas Kannur, the senior counsel, seeks for and is granted 2 weeks' time to produce relinquishment deeds and any document of consent executed by the petitioners or deed of consent or the like said to be executed by the petitioners in favor of the BDA. The said documents to be filed on or before 21/7 after serving a copy thereof on each of the respective councils of the petitioner. ಎಲ್ಲ ಒಬ್ಬರಿಗೆ ಕೊಡೋದಲ್ಲ, ಡಿಎಲ್ ಜಗದೀಶ್ ಸಾಹೇಬ್ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರವ್ರ ಮ್ಯಾಟರ್ ಅವ್ರವ್ರು ಕೊಡಿ.
What I'm told is in some petitioners themselves are produced the relinquishment.
Then you rely upon that.
Yes, no, I'm just bringing it about.
We don't know. We are going by your 30,000-foot argument.
Absolutely not.
We still haven't come to the ground.
I'm supported and equitable also. That's why I'm saying that. That is why I'm sorry, but I will vociferous only for this reason, because
no, your normal voice only is vociferous, Mr. Kannur, you know that. But what we are only saying is, come to the ground reality, argue each matter instead of a bird's eye view back.
Basically, you wanted to tell on the basic principle.
All these questions only clear in the draft manner known to the law. They only
Day before yesterday, Jammu and Kashmir High Court has said that property right is akin to a fundamental right. A division bench. Times are changing.
Right, which we cannot do because in case here we are only considering on what they are entitled to. Maybe the prayers are that.
You still have to satisfy us on what basis you took the land. If that is not a satisfaction that you can give us, if there is an illegality committed by you, it is not just a question of compensating the petitioners, but it would be a deterrent. What is the deterrent effect to be on BDA? So we will also initiate action against all persons who involved in this illegality. How did they take possession? Without, if there is a consent, no problem. If there is no consent, you are not authorized to ride roughshod and take land of anybody.
Because that second paragraph which your lordship asked me to read, they themselves say that we have agreed.
You
Now
should.
agreed for how much? That's a factual aspect.
That is what you will have to show us.
I will show, but at least agreement is there. That is there. They have accepted.
You will have to show us, because you are in the dock.
Absolutely.
You will have to show us that this is the agreement. ₹100 ಕೇಳಿದ್ರು ನಾವು ₹100 ಕೊಟ್ಟಿದ್ದೀವಿ. ನೀವು ಹೇಳಬೇಕು. ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ತೋರಿಸಿದ್ರೆ you are clear.
In some of them will show that ₹200 ಕೊಟ್ಟಿದ್ದೀವಿ.
Then please be rest assured that we will impose cost on that matter and dismiss that matter.
Yes, sir.
As abuse of the court.
That may not,
we will do that also.
Sure, because also to say that where BDA has done it is to be done, then even on them if they are not, if they are not
there won't be Article 14 violation.
Yes.
Article 14 will be followed.
Absolutely.
So if nobody else can take land illegally, BDA also cannot take illegally in the first presumption. We will list on Sri Gurudas Kannur, Senior Counsel further submits that the above matter is connected to blank. Yav kodtira list.
Now, they give it in a few days, 4-5 days time. They give it. In 2-3 days time.
So ಅದವರೆಗೂ ಈ ಆರ್ಡರ್ ಶೀಟ್ ಬರಲ್ಲ ಅದಕ್ಕೆ.
1 week time by that time they will.
ನೀವು ಎಷ್ಟು ಲಿಸ್ಟ್ ಕೊಟ್ಟರು ಅಷ್ಟು ಬರ್ಲಿ, ಆಮೇಲೆ ನೋಡಿ ಲಿಸ್ಟ್ ನಾವು ಕೇಳ್ತಾ ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು. The registry that connect all the said matters and on 19/7 at 2:32. Sorry, 21/7 filing 26/7. Further hearing, more. Interim order is extended.
And for the petitioner's case, Your Lordship, the respondent's statement of objection.
So, ಏನು ಮಾಡಬೇಕು?
Place a week's time, Your Lordship.
ಏನಕ್ಕೆ?
Respondent first statement of objection yesterday, Your Lordship, 056.
When it comes to the petitioner submit that the statement of objection has been served on him yesterday evening. He seeks for and is granted a week time to go through the same and address arguments. Relist on 12/7.
Interim order to be extended, Your Lordship.
Interim order earlier granted is extended till next date.
Yes, Your Lordship.
File it in the registry. You want to file rejoinder. Rejoinder applicant. Objection bada powerful. When it counsel for the respondent submit that he has filed a statement of objections which has been received by the counsel for the petitioner. Counsel for the petitioner seeks for and is granted 10 days time to file his rejoinder. Rejoinder if any by 14/7, we list on 19/7. Office will not. Or the signature ತಗೊಂಡಿದ್ದೀರಾ?
I pay for the petition number.
Number
60 million.
Yes.
Got that. The petitioner is allotted to the site.
Mr. Unni Krishnan?
I think, my lord, the petition could be allowed, my lord, this matter. Yes, that the site has to be identified.
Site has to be identified.
ಅದನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ Mr. Unni Krishnan.
I don't know how that has happened, but generally, my lord, they put a paint. I don't know, he says he's not, but it's our duty, we'll give it. When there's a conveyance, only thing, my lord, let him visit the BDA so that he can go with the engineer and then.
Yes. Petitioner is before this court seeking for the following release. The petitioner was allotted a site measuring 9/12. Where is the site?
Allotted six stage, Banshankari below.
Banshankari 6 stage. Number new ಏನು ಕೊಟ್ಟಿಲ್ಲ.
It's available at page number 14 below.
853, my lord, site.
Banshankari 6 stage. 4T block. Bearing number 853. Though the schedule has been annexed to the sale deed, the petitioner on visiting on trying to locate the property was unable to do so. Then the petitioner has requested the respondent to locate the site and display the site number board on the property, while his notice dated 6/12/2019, despite which the respondents are not active. Admittedly, the respondent has executed sale deed in respect of site number 853 in favor of the petitioner. In view thereof, I am of the considered opinion that it would be duty of the respondent BDA to locate the property, demarcate the boundaries, and display the site number on the said property. Hence, the respondents are directed to do the needful in terms of the above within a period of 6 weeks from the date of receipt of a copy of this order. Petition is allowed.
Please.
None appears for the petitioner today also. None were to appear for the petitioner on the next date of hearing. The petition will be liable to be dismissed for non-prosecution. Relist on 19/7. Instructions. ಯಾರಿಂದ ಬರಬೇಕು ಅಂತ then you have to do dispute between the government and BDA. Then you have to sort it out to that committee now. Litigation policy alidala para 6 para 7 ನೀವು dispute sort out ಮಾಡೋ ಇವ್ರ ಪಾಪ ಏನು ಮಾಡಬೇಕು. 63 learned counsel for respondent seeks for and is granted 1 week finally to file his objections and or make his submissions. Relist on 12/7. 12 bedwa 19. Lakshmi is 19. Already. Yes, Ms. Sampath. Yes, madam. Petitioner is before this court seeking for the following rules. The petitioner claims to be the absolute owner of property bearing survey number 39/3, old number 39/1, measuring 5 acres, excluding 7 gunters of Karad, situated in Penchanapura village, Tingeri Yogi, Bangalore South Taluk. The petitioner, after getting the property converted, had applied for sanction of a layout plan, which came to be sanctioned on 17/5/2019. Thereafter, the petitioner has also executed a relinquishment deed on 9/7/2019 in favor of the respondent, in furtherance of which a work order came to be issued on 27/9/2019. The petitioner contends that the petitioner has complied with the conditions in the sanction plan as also in the work order, and is therefore entitled for issuance of final approved layout plan. Despite repeated follow-up, the petitioner has not been furnished with the final approved layout plan, and as such, the petitioner is unable to implement the layout for the last 2 years, which is causing tremendous inconvenience to the petitioner. It is not in dispute that the layout plan has been sanctioned and thereafter the relinquishment deed has been executed and the work order also issued. It is therefore required for the respondent to issue necessary final approval for the sanction plan if all the requirements and the law have been fulfilled. After the work order was issued, the executive engineer has recommended the approval of the layout plan by his letter dated 19/2/2020, despite which is not been done. In view of the, there is a requirement for issuance of final approved layout plan, more so when there is a recommendation made by the concerned executive member. In view thereof, I pass the following order. A memorandum is issued directing the respondent to consider the letter dated 29/5/2020 at Annexure L of the petition, Annexure L, within a period of 6 weeks from date of receipt of a copy of this order, and issue a final approved layout plan if all the requirements are fulfilled. The respondent shall act on uploaded copy of actually the original. So you are not even entitled for being heard. That your objection. Counsel for the respondent once again seeks for a short accommodation to file his statement of objection. Objections if any to be filed on or before 14/7, released on 19/7. Estimated objection adjournment. When will you file it, Mr. Gautam Dev Shivulal and counsel seeks for and is granted 2 weeks time finally to file a statement of objection. Objections if any by 21, released on 26. Yes. Already issued notice long ago. What 14/6 you have issued notice. Sachin 1983 ಇಂದ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? Instructions ಬರ್ಲಿ. There is acknowledgement you have issued. We'll have it on 19. By that time, you return the original salary. And also, what are the damages that you are going to pay from 1983 till now? We are putting your notice on both the facts. Usually ಮಾಡಲ್ಲ, ಇವಾಗ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು? Or they can't take any, they can't take any loan, they can't develop, they can't get a plan sanction. From 83, they have not been able to use the property, their own property, because of you. Unless you show that you have given the same. Counsel for the respondent once again seeks for and is granted 2 weeks time, sorry, 10 days time to obtain instruction, make a submission as regards whether the sale deed has been returned to the petitioner and or not, released on 19 July. At 2:30 p.m. 2:30 Gandhi. You don't look 81 though. That is good. ಏನಮ್ಮ ಆಯ್ತು ರಿಕನ್ಸಿಲಿಯೇಷನ್ ಆಯ್ತಾ? We are not concerned with your sections, we are concerned with BDA. Interim payment adru ಮಾಡಿ ನಾವು. When a counsel for the respondent submit that reconciliation is more or less complete. We have seen the letters. We have seen the letters which are in the file. And those letters are with the memo of retirement. We have seen a lot of letters in the file. Telugu letters they have said, you requested for instructions on so and so date, so and so date, so and so date. I have sent you 50 letters by spending money from my pocket for registered post. But I have not received any instruction, therefore I am retiring. 50 letters on that. In fact, that now they come with the Bharat. I will not. When counsel for the respondent submit that the reconciliation of accounts is the final stage, given 10 days time, reconciliation will be completed and any amount due will be paid. Released on 26/7. ನೀವೇ ಫ್ರೀ ಟೈಮ್ ಕೇಳ್ತೀರಾ? ಲಾಸ್ಟ್ ಟೈಮು ತಗೊಂಡ್ರಿ ಟೈಮು ಒಂದೇ ಸಾಕು. ಇವಾಗ ಎರಡನೇ ಸತಿ counsel for the petitioner seeks for and is granted 1 week's time. Released on 12/7. Basraj, ಮುಂದೆ 70. ಅವ್ರೇನ್ ಬರ್ಕೊಂಡೇ ಬಂದಿಲ್ಲ ಅದು. One copy. And counsel for the respondent submit that he does not have a copy of the petition, then counsel for the petition. Your copy ಯಾವ ಕೊಡ್ತೀರಾ ಹೇಳಿ? Then counsel for the petitioner undertakes to furnish one more copy by the end of the day today. Then counsel for the respondent seeks for is granted 2 weeks time finally ನಾವಿನ್ನ ಜಾಸ್ತಿ ಕೊಡೋಣ ಅನ್ಕೊಂಡ್ವಿ 19th. 2 weeks time finally to obtain instruction, make a submission, released on 26th. You return the file. We see Ramakrishna submit that you return the file and is no longer on the panel. Hence, Shri P.S. Satish is directed to accept notice for the respondent. Counsel for the petitioner is directed to furnish a copy of the petition along with annexures on the said counsel. None appears for the petitioner to the mail. Released on 26th.
For the petitioner in this case, my lords.
Yes.
That's
Ready.
I would like to bring it the knowledge of the lordship that this is the subsequent petition because all I have petition.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಾಗಿದ್ರೆ ಫುಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ಪೀಸ್ ಮೀಲ್ ಮಾಡಬೇಕು.
I will find my
ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿ? Counsel for the respondent once again seeks for and is granted 2 weeks time. Released on objections if any by 21st, released on 26th. ನೋಡಿ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ BDA ಅಡ್ಜರ್ನ್ಮೆಂಟ್. Connected, disconnected, objections are not there. And you seek for time. How many matters we have adjourned today? Very. Yes.
My lord, I am appearing for petitioner in this case, my lord. It is a writ of mandamus, my lord. Alternative site.
Mandamus go objections ಹಾಕ್ಬೇಕು.
Alternative site, my lord.
Particular site ಆಗಲ್ಲ ಮಿಸ್ಟರ್ ಸಂತೋಷ್.
My lord?
Particular site ಬೇಕಂತ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಇಲ್ಲ, no.
Alternate site.
No, my lord. Earlier petitioner
ಯಾವ್ದಾದ್ರು
was.
ಕೊಟ್ಟರೆ ನಡೆಯುತ್ತೆ.
Already they have been granted a site in Nagarbavi, my lord. Afterwards, what BDA did, as it comes to the buffer zone, they did not alert site to me anywhere, my lord. Entire BDA proceedings have stated that they are ready to give site in HRBR layout and CD report has also been filed, my lord. When the petitioner filed the writ petition, the petition was allowed and time limit was framed to give some site, my lord. Even though BDA did not give the site. So the petitioner filed a contempt petition. In the contempt, the BDA has filed an affidavit and granted a site. Entire proceedings. So HRBR layout ಅಂತಾನೆ ಬರ್ಕೊಂಡ್ ಬರ್ತಾರೆ ಸ್ವಾಮಿ. ಸೈಟ್ ಖಾಲಿ ಇದೆ, ಕೊಡ್ಬೋದು ಅಂತ. When we filed contempt proceedings, notice was issued as a matter of punishment. They allotted site in Nadaprabhu Kempegowda layout. In the contempt proceedings also there was a liberty.
If that is the thing, Mr. Vachan.
Just have given the representation to consider.
Make a submission. If in the contempt you have said you are going to give an HRBR layout.
Consider the representation. The representation was considered is given allotment in the which minority is not saying it is not correct. It is wrong in HRBL. But if the limits of the director is proceeded for HRBL, content not have been full, but we should have allotment.
You place it. Let us see.
In page number 76, my lord, they have written HRBR.
Respond number 2. Seeks for and is granted 2 weeks time finally to file this objection. Objection if any by 21st, released on 26th.
Please.
Shri Ramakrishna learned counsel for respondent submit that he has written the file and he is no longer on the panel. Then Shri J.C. Kumar, learned standing counsel, is directed to accept notice for respondent. Counsel for the petitioner to serve one more set. Objections if any by 28/7 released on 2/8. 2/8 and what? 2/8 green is working.
I appear for the respondent. Madam.
After reaching the entire, after reaching the allotment that are in the Vietnam, the limitation running the deal. After issuing the allotment that are most of it was exported and ultimately died on 11 to 1970, running the deal. Thereafter, not the petition and the achievement documentation to transfer their site in our favor. So inquiry has been conducted and the petition matter and recorded the statement of the petitioner and finally she was directed to file a joint affidavit and execute the indemnity bond. The same was executed and also file a joint affidavit which is running the so after the executing the indemnity bond, no action has been taken, hence in the representation of 4/11/2019, which is running the agreement. Then the STF has issued a notice to the petitioner to all the relevant documents and same has been submitted. So after submitting the all the records, they have issued the endorsement saying that there is no original premises channel for having paid the second line. She made, she already got a complaint before the police station, stating that she has lost the original channel for having paid the second line, which is in the file of the respondent file. Without considering the suspect, only the issued endorsements is not produced the original receipt.
Yes, Mr. Unikrishnan, don't you have any document as regards the payment?
My lord, my submission is the husband of the petitioner is said to have applied for a site in the year 1975. Right from 1975, they have not approached the BDA at all. Then, my lord, all that we have said is please show us original documents because we do not have any documents pertaining to this file. The main reason, my lord, is that my lord may kindly see page number 12. The City Improvement Trust Board, my lord, is said to have issued a receipt of 464 rupees for payment. My lord may kindly see the seal which bears the seal, my lord, regarding the receipt of that particular payment. It shows BDA. 1975 BDA.
What is this?
No, my lord, we doubted the veracity of these documents.
Seal ಯಾವ್ದಿದೆ ಕೆಳಗಡೆ?
BDA ಅಂತಿದೆ. BDA ಇರಲಿಲ್ಲ ಅವಾಗ.
Page number 13.
13, 15 ಎಲ್ಲ ಇದೆ ನೋಡಿ.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಅಪ್ಲಿಕೇಶನ್? Where is your application? And how did you receive this? Where is your application and RTI? ನಾವು ಕೇಳ್ತಾ ನಿಮ್ಗೆ ಒಂದೇ ಕ್ವಶನ್, ಅದು ಆನ್ಸರ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಬೇಡ ಅಂದ್ರೆ ಬಿಡಿ. Where is your RTI application? And how did you receive this document? And how did you receive these documents? How did you receive it? Was it by a registered post or personally you worked on that? So cover idea.
1975
ನೀವು RTI ಯಾವಾಗ ಹಾಕಿದ್ರಿ? 75 ಎಲ್ಲ ಹಾಕಿದ್ರೆ RTI.
Because the letter was issued by the Bangalore City Inspector's Court in Public Petition Department in 1975.
How did you get this document?
So which is in our document. This is my husband has received those documents.
ಅಷ್ಟೇನಾ?
During his lifetime. Unless the B one, the remitting channel.
Is it your contention that you got it in RTI or is it from your own documents? Nim documents ಅನಾ? Then BDA seal ಹೆಂಗ್ ಬರುತ್ತೆ 75 ಅಲ್ಲಿ? BDA Act ಯಾವಾಗ ಬಂತು? ಅದಿದೆ ಬಟ್ ಸೀಲ್ BDA ಇದೆ.
Investment issue ಮಾಡೋದು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಬಿಡಲ್ಲ. ಈಗ ಮೈ ಕೌನ್ಸಿಲರ್ ಸಬ್ಮಿಟೆಡ್ ನಾವು ನಿಮಗೆ ಬೇರೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಒಂದು ಚಾನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. So that's what I basically use this because arise along the by the friend. When you fill up challenging the endorsement issued by the BDA authority. ಈ ಮೂಲಕ ಸದರಿ ಯೂನಿವರ್ಸಿಟಿ ಸಂಬಂಧಿಸಿದಂತೆ ಮೂಲಕ್ಕೆ ಹಂಚಿಕೆದಾರ ದಿವಂಗತ ಸುರೇಂದ್ರರಾವ್ ಅವರ ಹಂಚಿಕೆ ಪದದ ಮೌಲ್ಯವನ್ನು ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಪಾವತಿ ಸಂಪರ್ಕ ಬ್ಯಾಂಕ್ ಸಲ್ಲಿಸಿದ ನಂತರ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು.
Yes.
If they are admitted, they are not denying those documents. This is the document issued by the BDA.
That is why they are asking you for the original to verify because they don't have this. Mr. Vasant Kumar, your document bears a seal of BDA which did not exist as on that date. So this is a fabricated document. We will initiate criminal proceedings against your client.
But never, they never said that it is a fabricated document.
They don't need to say when we see it, it's enough.
Verify that their own right, verify they pass a appropriate order.
We will pass appropriate orders now. Because you are producing a fabricated document before this court. Our madad bekagilla. You have produced a document with BDA seal which BDA did not exist. They don't need to say it.
Those are the fabricated document. The endorsement issued by the BDA itself to produce the bank challenge.
Nobody needs to say anything. If a fabricated document is produced before us, we can take action.
Yes. So definitely it's a fabricated document that will take legal action. That's absolutely I have no objection there.
The petitioner is before this court.
Bank challenge for indicated understand.
They ಮಾಡ್ತಾ ಇದೀವಿ. Petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that the petitioner's husband had been allotted site bearing number 1840 measuring 25 by 40 in Kengeri satellite town in the year 1975. And her husband had made payment of the amounts due to the said site at that point of time. Since the sale deed was not executed and her husband expired on 11/2/2017, the petitioner has been following up with the respondent for execution of the sale deed. Along with the documents produced, along with the writ petition, in the documents produced at Annexure B, he is one of the receipts dated 11/11/1975. BDA actually. ಬರ್ತೀವಿ ಅದಕ್ಕೂ ಬರ್ತೀವಿ.
Act came into force, my lord, from 20th day of December 1975 under the BDA Act of 1976, my lord.
That is what we are looking at the date. Annexure B being a receipt. ಬರ್ತೀವಿ ಇರ್ಲಿ Mr. Vasant Kumar. Being a receipt said to be issued by the City Improvement Trust Board, Bangalore, dated 11/11/1975, in favor of the petitioner. The said document bears a seal issued by the rubber stamp of Bangalore Development Authority Extension Counter. Annexure C is one more receipt dated 3/9/1970. ಏನಪ್ಪ ಡೇಟ್ ಇದು
77 75
77 is
75 ಇಲ್ಲ 11/11/1977.
this is fine
11/11/75
ಮತ್ತೆ ಇದೆಯಲ್ಲ 77 ಇದೆಯಲ್ಲ ಮಿಸ್ಟರ್
ಇಲ್ಲ 75 ಇದೆ ಟೈಪ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ 75 11/11/75
The Annexure C is 77, Mr. Unikrishnan. 3977, 500 rupees.
3977. ಹೌದು.
That is BDA. BDA was there.
ಇಲ್ಲ ಫಸ್ಟ್ ಒನ್ ನೋಡಿ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಒನ್ ಇಸ್ ನಾಟ್
First one ಆಯ್ತು, but second one ಇದಲ್ಲ.
ಸೆಕೆಂಡ್ ಒನ್ ಅದೇ BD ಅಂತಿದೆ. ಹೌದು ಹೌದು. We doubt because we don't, this itself we are doubting because we have no records at all. So we only said that please produce the original, and if you are right, we will go on with the allotment. If
Annexure G note.
The witness conducted the survey and the record statement of petitioner and subtarget Mahadar, they are received in Mahadar, wherein the revenue inspector, the children of this
That is in 2019. ಅದು ಬೇರೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಮಾಜರ್
then the petition being aware, she may represent to transfer the government in her favor. Thereafter, the conductor survey, record the statement of the petitioner.
Who is in possession of this property? 1840 site number, who is in possession?
No, we start from the arbitration because other years the entire amount.
You are not in possession.
No, we are not.
But Annexure A. Wherein counsel for the respondent submits that the said document is on the ex-facie fabricated document, inasmuch as the Bangalore Development Authority came into being only on 20th day of December 1975, and as such, the seal dated 11/11/1975, bearing the seal of VDA, is ex-facie a fabrication. If that be so, it is for the respondent to have initiated necessary action against the petitioner for fabrication of the documents of the respondent. The counsel for the respondent seeks for and is granted 2 weeks' time to verify his records and make his submissions. Released on 19th. If you seriously feel so, then you file a complaint, Mr. Unikrishnan.
Lord, what we ask for is to show the originals. If it is genuine,
He doesn't have.
it is not so.
He doesn't have because he has
my
lost
Lord,
it.
my Lord, the complaint is filed only in 2020. It is all
When
created.
after you asked him, now if you feel this is a fabrication of your records by fixing your seal, then you should put your.
Yes, my Lord. He'll verify.
77. None appears for the petitioner today also. If none were to appear for the petitioner on the next day of hearing, the petitioner will be liable to be dismissed for non-prosecution. We list on 19/7.
I appear for the respondent, your lordship.
Yes.
And the petition may be allowed, your lordship. The petition is entitled for the relief sought for your lordship.
Petitioner is before this court seeking for the following relief. The petitioner I filed an application for allotment of site by paying the registration fee by way of demand draft on 7/6/2002. Along with the said application, the petitioner has submitted necessary documents to show that the petitioner belongs to SC/ST category 1 and as such is entitled for preferential treatment. After receiving the initial amount, the respondent number 2 issued allotment letter allotting site number G8-SG-2496 in Nadaprabhu Kempegowda layout, measuring 9 into 12 meters. Since the petitioner was not in a position to deposit the balance amount, while letter dated 7/2/2019, she requested for payment of the installments in 3-year time period. No reply was received in respect thereof. However, on 6/7/2020, the respondent had issued a show cause notice as to why the allotment should not be cancelled. Petitioner replied the same on 23/7/2020, relying upon section Rule 13(1)(b) of the BDA allotment of site rules 1984, contending that since the petitioner belongs to scheduled caste, the time limit of 3 years could be granted for payment of the amounts in equal annual installments. The petitioner also deposited the first installment of rupees 6,65,035 to establish a bona fides. Despite the same, the respondent rejected the request and issued an endorsement dated 16/1/2021 at Annexure P, cancelling the allotment made to the petitioner. Isn't that background? The petitioner is before this court. Correct. So Rule 13(1) reads as under. It is clear from the said rule that there is a special provision made for persons belonging to the scheduled caste category to avail of facility to make payment of the amounts by way of installments. It was therefore but required for the respondent to extend the said facility to the petitioner instead of cancelling the allotment. More so when the petitioner has made payment of sum of rupees 6,65,035 and the petitioner is willing to make payment of the balance in 2 equal annual installments. In view thereof, I am passed the following order. Certiorari is issued, the endorsement dated 16/1/2021, issued by respondent number 2 at Annexure P is quashed. A mandamus is issued directing the respondent to collect the balance. When did you pay the balance? When did you pay the balance? Where have you said that? Where have you said that? We don't see. Was deposited. Okay, cancel on 16/1. After that, you deposit. After the cancellation, the petitioner has deposited the balance amount of rupees 15,43,702. You're making the dates are wrong.
No,
because prior to that you made payment of 6,65,035 and thereafter made the balance payment of rupees 15,43,702 on 24/11/2020. They are asking only interest. But you are not liable to pay interest because you have a 3 year. Thereafter, when the endorsement came to be issued on 16/1/2021, calling upon the petitioner to make payment of sum of rupees 7,44,078 as interest for delayed payment. It is in the above background that the petitioner is before this court. When Rule 13 provides for payment by a person belonging to scheduled caste category in 3 annual installments. In the present case, the payments have been made by 2020 when the allotment letter was issued on 3/11/2018, and the considered opinion that the entire payment has been made within the 3-year period. If that be so, the question of levy of any interest and payment of any interest by the petitioner would not arise. Hence, I pass the following order. The certiorari is issued. 16(1) at Annexure P is brought. The respondent is mandamus is issued. Respondent is directed to execute a sale deed in respect of site number B8 SG2496.
So, Lordship, it will be lease cum sale agreement here, Lordship. Sale deed can agree.
Your lease cum sale, are they?
Lease cum sale.
Lease cum sale agreement. B8 SG2496 in Nadaprabhu Tempegada layout measuring 9 into 12 meters. Within a period of 8 weeks from date of receipt of copy of this order without insisting for payment of any interest. Subject, however, to the petitioner making payment of the necessary stamp duty and registration.
My lord, I appear for the petitioner on this matter.
Yes.
My lord, this is a writ petition that has been filed challenging the letters issued by the respondent.
Just a moment.
Please, my lord.
Huh? Okay. So, Yavaga. Objections are there. In the objections. Objections in life. When did you file it? Learned counsel for response submit that he has filed statement of objections on 28/6. Have you received copies, madam?
Please, my lord, we've received copies. My lord, if I may be permitted to make one submission, we have also filed an application for direction, my lord. They have filed objections to the same. May I request that the matter be listed on hearing on IA because there's an urgency that we have in this matter.
It will come up, madam. Everybody has urgency.
My lord, may I request for on 12th, my lord.
Registry is directed to verify and put up the objections as also the application filed by the petitioner and objections to the said application. Release term 19/7.
My lord, may I please request for 12th, my lord, the construction of the petition has come to a standstill. We are unable to proceed because we are not able to modify our sanction plan, my lord. That is the difficulty we are facing.
Take it up on 19.
Please, my lord.
Serial number 80, I appear for respondent, Your Lordship. Your Lordship, the only contention is they are asking for a particular site to be allotted, Your Lordship. She is entitled, at another also I have produced. Site can be entitled in randomization.
Number ella kottibittidiranga chestunna. Number chakbandino kottu. Alternate site. Yadaru. Petitioner is before this court seeking for the following review. The petitioner submits that one Mr. M.N. Murthy had been allotted site number 1447/2, measuring 50 feet by 80 feet at M. Vishweshwaraya layout, first block, first phase, Bangalore. And the sale deed was executed in his favor on 31/8/2005. Who sold the same in favor of one Mrs. Suma S. Channel on 18/11/2009. Who in turn sold the same to the petitioner on 3/7/2020. The property had been transferred in favor of the petitioner. Thereafter, the sites have been formed out of survey number 128, 129, and 130 of Nagdevanandi village. Those survey numbers have been denotified from acquisition proceeding and restored to the landowners. And as such, the petitioner made a representation for allotment of alternative site in lieu of the opposite site. Office proceedings were also drawn up, recommending the allotment of alternate site to the petitioner. The representation was also given by however, no action was taken, hence the representation was given by the petitioner on 5/8/2021 for allotment of site number 1282 having the same measurement on the ground that the said site was vacant. Correct. Despite the same, no action has been taken as said the petitioner is before this court. Shri S.T. Vasant Kumar, Learned Counsel submits that though site number 1282 has been mentioned in the representation given by the petitioner is willing for any similar alternate site having the same measurement in Vishweshwaraya layout to be allotted to the petitioner. In view thereof, considering that the land in which the opposite site had been formed having been denotified, we consider the opinion that it was the duty of the PDA to have allotted an alternate site to the petitioner without even waiting for the petitioner to make any submission in that regard. In view thereof, I pass the following order. The mandamus is issued directing the respondent to implement the order of the first respondent dated 5/8/2021 at Annexure H and allot a site measuring 50 feet by 80 feet in N. Vishweshwaraya layout within a period of 6 weeks, 8 weeks from date of receipt of a copy of this order. Will act on uploaded copy. Objection ಆಗ್ಬೇಕಾ? Counsel for response seeks for and is granted 10 days time to obtain instruction and make a submission. Pre-list on 19. ಒಂದು ಹಾಕ್ಬಿಟ್ಟು ನೀವು ಹತ್ತರಲ್ಲಿ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂತಾ ಇದ್ದೀರಾ. Shri Gautam Desi Ullah, Learned Counsel for Respondent seeks for and is granted 2 weeks time finally to file a statement of objection if any by 21st, 25th, 25th and 26th.
For the respondent, my lords, statement of objection has to be filed, my lords. 2 weeks time may be kindly granted.
Fourth round of litigation.
For me?
Fourth round of litigation.
I have received paragraph. File the objection. I file it 2 weeks time.
Learned Counsel for Respondent seeks for and is granted 10 days time finally to file his objection. Objections if any by 15th, pre-list on 19th. None appears for the petitioner. And a counsel for the respondent submit that he has filed his objections. Readings being complete, released on 26/7 for final hearing.
Okay, for the petitioner in this matter, Manoj, land was acquired for Arkavati layout, Manoj. As per
the, to go to the committee, Mr. Shetty.
No, not that. We're not challenging acquisition, Manoj. We are seeking for implementation of Annexure B. Under the 60/40 scheme, there's already a decision taken to allot as per Annexure B, page 14.
That also the committee is seized off now.
No, Manoj, this is not regarding those are challenged to the acquisition. These are 60/40 scheme, Manoj. For example, Manoj.
Even that the committee has to see which site to allot to whom.
It's already been done, Manoj.
Number ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ Manoj. Page 14 ನಲ್ಲಿ.
Page
14 Manoj. 12th January 2018. It's already been reserved.
Number identify ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದಾರೆ. I identify.
Annexure B, page 14.
Page 14 in Annexure. In fact, sketch also.
ಸಂಖ್ಯೆ ರೆವಿನ್ಯೂ ನಿವೇಶನ ಸಂಖ್ಯೆ ಅದು ನಿಮ್ದು ಹಳೇದು, ಅವ್ರಿಗೆ ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ. You'll have to go there only, Mr. Shetty.
The Annexure G, page 49 may be kindly seen for a moment, my lords.
49.
49. This is a sketch prepared by the BDA, my lords. In fact, it's not disputed, my lords. In fact,
It is disputed. There is no identification, Mr. Krishna is saying. He'll have to go before the committee. The petitioner is before this court seeking.
if I may submit, my lords, what is going before the committee are not such cases, my lords, where the acquisition is concerned as per Supreme Court direction. I do not come within the Supreme Court directions, my lords. In terms, in so far as
not about Supreme Court direction, it is the direction by the coordinate bench at para 91.9.
Justice Arvind Kumar judgment, my lords.
Para 91 nodi, LL ಹೋಗ್ಬೇಕು ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Please, my lord. Then I leave it to your lordship, sir.
ಆ committee ಹೋಗ್ಬೇಕು. Keshwanayan Sahib committee ಹೋಗ್ಬೇಕು.
No, please, my lords, as per. Can I request, my lords, only thing is having annexure B having been passed allotted in the Kumar judgment is a subsequent judgment.
Your earlier numbers, not BDA side number, Allah, the revenue side. Petitioner is before this court seeking for the following release. The petitioner submits that he is the owner of. Petitioner submits that they are the owners of residential site measuring 60 by 40 each, bearing number 22, 23, 37, and 36, found out of survey number 27, Ennur village, Kasbahuli, Bangalore, which has been acquired for the purposes of Arkavati layout. The petitioner submits that they are entitled for the benefit of 60-40 scheme, and as such had applied for allotment of site number 22, 23, and 37 above mentioned, which has not been considered, and as such the petitioner is before this court. The coordinate bench of this court, while considering matters relating to Arkavati layout, has formed a committee where all these matters have been considered. More so in terms of para 91 bracket Roman 9 of the said judgment. In view thereof, I pass the following.
My only subject to my Mr. Krishna, I am not that this what was challenged before Justice Arvind Kumar was a challenge to the acquisition, my lords. In
all of it, where the sites have been cancelled, alternate sites have to be given, everything is there. Because the committee will have an overall view as to which sites are available.
This is a case of a. Please, Manas, I'll leave it at that.
Yes. Mr. Kiran?
Responding to your lordship. Lordship, in this matter, I request that concerned officer may be present because there is a genuine effect has been happened here. There is a day and time may be fixed, your lordship, and the presence of the officers may be made. So there is the better person to explain.
Statement of objections are
how to rectify this mistake. The effect is real. There is a mistake happened, your lordship.
You are not able to understand.
We are admitting the mistake, the petitioner is attended to the
It shall be rectified and copy of the possession certificate given to Shankar Reddy and Telest.
Yes, your lordship. That number has to be rectified because town planning has
Sai Dilip has filed this.
Why
will you issue it to Shankar Reddy?
Shankar Reddy is given the same site number, your lordship. Now that has to be rectified.
Two people have been given the same site number.
Same site number.
But when I applied for Tata, what the response was, in respect of site number 8, there is already a Tata existing, therefore we can't do it. But basically, confusion has arisen. Page number 34.
Yes. A, B, C, B, A.
That's site number 8. Site number 8 is not, it's already allotted to another person.
Another is 8/1. Next is the column side, which is that option that public notification of the email.
ಅದಕ್ಕೆ ನಂಬರ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
The option
Eight.
notification, they are indicated as 8/2. And now they say that the site number 8, in the site number 8, because Tata is running open, they don't find.
How can you have this bar 1, bar A, B, L as continuous number ಬರಬೇಕು? How can you have all these kind of numbers, Mr. Achiran?
That's the reason I requested your lordship. The concerned officer is the better person.
ಇದು ಬಾರ್ ಎಲ್ಲ ಬಂದ್ರೆ ಏನೋ ಕಿತಾಪತಿ ಆಗಿದೆ ಅಂತ.
That is corner cutting, your lordship. When the town planning approves a corner site, the engineering section sometimes cut that site into 2 pieces and allot one side to other. That is what the confusion might have happened in this case matter, your lordship. Hence, if the concerned officer is present, it will be better to explain what exactly.
Who is the concerned officer?
Lordship?
Who is the concerned officer?
A town planning member and engineering member along with the DS4, your lordship. These are the 3 concerned officers for this.
After hearing the matter for some time, I consider opinion that the presence of the Deputy Secretary report, that is respond number 2, is required to ascertain the identity of the property in question. Hence, the Deputy Secretary 4 is directed to be present in person before this court on 19/7/2022 at 2:30 p.m.
Along with the Deputy Secretary 4, town planning member and engineering member is present.
Along with such officer as may be required and documents that may be required.
Much obliged.
Including the allotment 5. ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ. Yes. Yes.
PDS says they will unilaterally pass the resolution where they will give you only 50% of monthly compensation, remaining 50% you are required to pay alternative land.
What do you want? What do you want?
I want money on the alternative land. Instead of 175.78 square meter, area was 45.4. The grade separate between the continuous state and the marginal road.
Yes.
And after the final notification, award was passed. The subsequent the BD has made the becomes the effect of the government, stating that to return the project from the BD and hand over to the BDM. The matter in the matter was pending before the state government. Now the who have the media to recollect that the word
and do what? So old actor ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ ಮಿಸ್ಟರ್?
But once the scheme of awarding compensation as a national policy is laid down, then the exception is permissible only in terms of Schedule 4.
Who is the respondent?
But Sagar, what's the proceeding? This is a view which was taken by.
This is Karsam Singh old story, Mr. Old story, 2022 new story.
2022 also was taken the same view that there cannot be 2 aspects of awarding compensation. So far as awarding compensation is concerned, but I understand that so far as section 24 is concerned, that there will be.
No, not 24.
Awarding compensation is concerned, this is the view which is taken even as on today.
What is judgment of? This is Nazir has passed an order saying that.
That order I have seen it. Justice Nazir says in relation to the PRR, what was the notification which was passed prior to 1/1/2014?
It is as regards
that
BDA acquisition. BDA acquisition.
Under the PRR acquisitions under the BDA Act, Justice Nazir has passed an order. I have gone through that by dealing with the further miscellaneous applications.
No.
This issue is brought up and Justice Nazir has taken a view on one of the applications which was filed, stating that in respect of PRR, award need not be passed But under the new 2013 Act, it should be passed under the old Act. This is the view taken. But here is a case where, let's say he's a man submitting yours. It will be running contrary to a constitution bench judgment, which your assistance is required to follow. A 7th bench judgment, which is being followed by the absence case. This is ultimately what has been had even in this court. There are just because one paragraph of the 7 judges which is expected in this case. This is that paragraph number. At page number 331 words.
Yes.
Nagpur Improvement Trust case is expected consisting of para 30.
Nagpur right to Indore 1 to Indore 2
This is by 7 judges bench. Nagpur Improvement Trust case pertaining to compensation. I can understand with reference to the other schemes of acquisition, there is no difficulty. But this is the settled position of by a 7 judges bench, which is not disturbed. And if you also go to see section 105 of the Act should exclude the provisions. It is not the other way around. It is the scheme of the Act. I just take the version to the scheme of the Act also. Para 30 is equally.
You produce that judgment also, we will hear you. That counsel for the petitioner seeks for and is granted a week's time, a 10 days time. You produce material or produce material? Release and 19/7. Let us read that judgment. We don't have that copy here. I don't take it from the view. Copy separate it from and give a copy to Nimatra Idea. Nice. Annexure K. How long will this take, Mr.? This will take some time. We'll have it on another. Akilwa? Objections ಏನ್ ಆಗ್ತಿಲ್ಲ. Counsel for response seeks for and is granted 2 weeks time to file a statement of objection by 21st, release on 26th. Well, 92. Yes, Mr. Ular. Who is carrying out the illegal construction, Mr. Counsel? Oh, Resur Bedwa. What is their names? No, find out who it is. You can't ask like this. Really, the complaint. Connection? Is the builder putting up the construction?
No.
If we find that, Mr. Counsel, If you find that you have suppressed it and you are filing this kind of a petition, we'll direct Mr. Ullal to find out who is constructing. Shri Ullal seeks for and is granted 2 weeks time to file a statement of objection. He is also directed to verify as who is trying to put up construction in the subject property. Relist on 19/7. Before relist on 19/7, 94, 95. 94, 95, 96, 19/7, 97 to 101, 26/7. So it has to go to the committee. No. So after allowing it, it's gone to the committee, Alva. So you have to go to the committee again.
Saying that there's a nursery. And so he sought for confirmation of his representative. He's seeking for party.
101 relist on 26, 102 to 105.
Serial number 101, my lord.
Yes.
My lord, interim order in the matter.
Wherever interim order is there, we look.
In fact, the was given on the answer, moved it forward. Instead of interim order, now there is student act.
102, 104, 105. Relist on 18, 103, relist on 19/7.
My lord, in serial number 101, you challenged the Arkavati notification, my lord.
Yes.
My lord, we will also have to go to the committee, my lord. Till such time the BDA takes a decision, my lord, pursuant to the committee's report. My lord, the interim order may kindly be.
And one petitioner is before this court seeking for the following weeks. The coordinate bench of this court, in so and so, directed so and so, will formulate to the company. In view thereof, I pass the following order. Until the order of the, needless to say that until the committee takes a decision, the respondent shall not interfere with the possession of the petitioner if not already done. If not already done, you establish.
I'm grateful.
ಇಲ್ಲಿ interim order ಇದೆಯಲ್ಲಪ್ಪ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Otherwise we'll have to hear on that. So then you can use it there. Will be extra. ಇವಾಗ ಏನ್ ಮಾಡ್ಬೇಕಪ್ಪ? ಡೇಟ್ ಕೊಟ್ಟಾಯ್ತು. ಎಷ್ಟು ವರ್ಷಕ್ಕಿದೆ? 61. ಯಾವತ್ತಮ್ಮ? Either 12th or 19th, that's all. 61 12. 11/7 it cannot be 11/7. 103 11/7.
My lord, serial number 101, my lord, interim order may kindly be extended, my lord.
We have extended it.
Please.
100